Yes. And mentioning online. Yes. Item 1.
Item 1, instruction allowed.
Report has come.
Yes, sir.
Pursuant to the order dated 10/7/2025, the IIC Town PS Tenkana has placed on the recorded report entirely asserting that the sole appellant is alive. Matter is ready for hearing. Please continue, Coros Police. Yes. Item 2.
Item 2 is also allowed.
Period undergone.
So period undergone to
Period undergone.
Period undergone to asking. Calculate the alive. Say, खाली instruction that's allowed.
White order dated 1/7/2025. This court directed to obtain the instruction regarding the whereabout and well-being of the appellant, as well as the period the appellant has already undergone. The report by IIC Dharamshala PS dated 20th of July 2025, though indicate the well-being of the and whereabout of the appellant, but the period undergone now between of the so period undergone.
Right. Yes.
Yes. Item 3. Yes.
So 3 is also the asking. 3 is कौन से पाऊ ना आंधे से झारखंड साइड रो लोग कंपनी रे चाकरी करते रे बच्चे माने आसुन.
Report about it.
Yes, sir. So मिलुनी बोली कहूँ not traceable. जोड़ा last report देखते रे सही था कहूँ.
Okay. Report about it.
Aye.
Yes. Item 4.
4 report सर से दो जने but he is alive also.
Alive.
Aye.
Shall I record it?
Yes, sir.
Okay. You get the report. I'll.
Yes.
Yes. Okay.
Then pass over.
Pass off. Yes. Give the report. Yes.
Yes, sir.
Yes. Hearing. Item 5.
May I please, Lordship?
Yes, madam.
My Lord, the offences are under section 395 and 457 IPC. 6 appellants, my Lord.
Yes.
Appellant number 3 is dead.
How many appellants are there?
6.
Total 6. 6 appellants, sir.
My Lord.
Who has died?
3.
3 has died.
My Lord.
So this appeal survives for the rest of the
Rest of them.
appellants.
I'm
Yes.
appealing for the rest of them.
What is the offense?
In my brief, around appellant number 2 also died in August 2020 will get lekha is, but there is no report such a power. But 2022 died will lekha is appellant number 2.
Very neat. Order to that effect. Abatement order. He has died.
3 is dead. I have the order.
You're asked to get the whereabout and well-being of the other
Other
appellants which
other
you,
4 they are accident, but
which you could not. So therefore, this matter has to proceed. Let us start the matter. Let us start.
And actually, this matter was already heard before Honorable Justice C.R. Das, but it was posted for judgment, but then the assignments were shuffled or something and it has come up again, my Lord.
Was it reserved for judgment?
Yes, judgment was reserved earlier. Of course, he might have just said it orally, but the argument was concluded.
Nothing is there, madam.
My Lord, I'll argue it again, my Lord.
Yes, if you are ready, you argue.
Yes, I'm ready.
Yes. Let us see.
My Lord, the date of occurrence is 12/10/1982.
Yes.
My Lord, FIR was registered against 13 persons.
13%.
Yes.
Okay.
Well, the allegation is that 30 to 25 to 30 persons, including women, barged in into this person's house, and they looted grain and from the granary, and some gold and silver ornaments and other household articles from the house. After having tied up one or two the house inmates, and they also injured one of them.
Yes.
My lord, after facing trial, all of them were acquitted, my lord. 16 persons faced trial, all of them were acquitted. My lord, then the informant preferred revision before this honorable court on 1989, my lord. And that revision order, it was remanded for fresh, uh, not for fresh trial, of course, but for fresh judgment.
Fresh hearing.
Based,
Fresh
yes,
hearing.
yes,
Yes.
based on the facts.
Then in the second round, these people were convicted.
Second round, my lord, 6 out of the 16 persons were convicted.
13%.
13 FIR is against 13 persons, but trial 16 persons faced.
Charge sheet was filed against 16%. They were acquitted, all of them were acquitted by
All
the trial
acquitted.
court initially.
Yes,
The
initially they were
complainant
acquitted.
came in revision court remanded back
Yes,
for fresh determination.
my lord.
And after remand, 6 people were
6 were
convicted.
convicted.
Let us see what are the allegations. Come to the first FIR. Read the FIR. You have paper book with you,
Lord, most of it is not very legible, but I do have.
but in this FIR is written in Oriya. Just read it. It's FIR. What is it? Who is the informant?
Informant is PW7, my lord.
PW.
7.
Read PW7 then.
Yes, my lord.
He is the revision petitioner.
Yes.
He filed the revision.
Yes, my lord.
Okay. Let us see PW7. Come.
PW7, my lord.
Hmm.
A dacoity was committed in our house on the night of 12th October 1982. On the night in question, my father, my mother Pushpalata, PW1, my brother Bijay Mishra, PW2, my sister-in-law Basanti Mishra, PW3, her children, another younger brother of myself and myself were present in the house. My brothers Bijay, Santosh and myself were sleeping in one room. My sister-in-law Pakkan was sleeping with her children in another room. My father was sleeping in another bedroom, and my mother was sleeping in a passage room near the body door. We heard a knocking sound in our body door. My brother woke me up saying that somebody was knocking at the door, and hearing this, my brother Bijay and I got up and came out. And by that time, I found that the miscreants had entered into our house. There were 25 or 30 in number. Out of those 25 or
You have
30
25 and 30 number. Huh?
Yes, ma'am.
Yes.
Out of those 25 or 30 persons, all the accused persons present in court had entered into our house. Each of the accused persons are my co-villagers, and I am well acquainted with them. I know their names, named and identified each accused correctly. They were armed with lathis, churas, etc. They had also held torchlights. By the time of the entry of the accused persons into our house, my father had already come out of his bedroom. Accused Bhaba Panda assaulted my father with slaps and fist blows, and also asked my father to disclose the place of concealment of our valuables. Then the miscreants tied my father.
Baba Panda is the appellant number?
1, my lord.
Appellant number A1, huh? A1. Okay. Yes.
And also asked my father to disclose the place of concealment of our valuables. Then the miscreants tied my father to a pole. When my mother Pushpalata attempted to rescue my father, accused Bhaba assaulted my mother and pulled out the silver necklace and the gold earrings from my mother. Accused Bhaba assaulted my mother with a lathi. When my brother Bijay obstructed the accused persons while assaulting my mother, accused Bengali gave a blow with his knife which
Accused
struck
Bengali is accused number?
2, my lord.
A2. Okay. A2. Yes.
With his knife which struck on the left side of his chest, though by mistake and owing to confusion I had stated in the FIR that the blow struck on the right side of his chest. Then accused Bhaba, Bengali, Balram Panda and Kasinath Tripathi.
Balram is A. Balram is
5.
A5.
Yes, sir.
A5. Yes. Proceed. And
Kasinath A6.
A6.
Yes, sir.
Okay.
Went near my sister-in-law Pakkan Mishra, and one of those accused persons pulled out the earring of Pakkan from her right ear. I do not remember the accused who had attempted to pull out the earring of Pakkan due to lapse of time. Then my mother shouted not to touch Pakkan as she would voluntarily surrender her ornaments. Then Pakkan took out all her ornaments from her person and delivered them to the aforesaid accused persons.
Pakkan is
3.
he who died, huh?
No, nobody died. Just
PW3, oh, the witness. His brother. Okay. Yes.
One of those is a sister-in-law of the informant.
Yes. Yes.
One of those four accused tried to pull out the sari which was worn by Pakan, and my sister-in-law said that she would voluntarily take out the sari and deliver it to the accused persons. She forbade the accused persons to touch her, and so saying, my sister-in-law Pakan wore a torn sari and delivered the other sari which had been worn by her to the accused persons. Due to lapse of time, I do not remember the accused who attempted to pull the sari from Pakan. Accused Bhaba, Bengali, Kasinath, Balram Panda, and Nakul Naik.
Nakul Naik.
Nakul Naik is
Nakul Naik.
Nakul Naik is 4.
A4.
4.
A4.
Entered into the bedroom where we three brothers were sleeping. The said five accused persons confined my father, my mother, myself, and my sister-in-law in the said bedroom and guarded us. Those accused persons carried the trunks and boxes laying in the said bedroom to the courtyard, and after breaking open those boxes, contents were removed by the accused persons. Those boxes contained clothes such as pants, shirts, etc. My wristwatch was also placed in the attache, which was broken open, and wristwatch was removed. These five accused persons broke open the boxes lying in the bedroom of my sister-in-law Pakan and removed properties therefrom. Accused persons other than these five accused, whose names I do not remember now, entered into the room of my father and removed properties from that room. The accused persons also removed paddy from the granary, molasses, etc. I cannot name those accused persons. On the next day at about 5 p.m., I lodged a fire at Tihidi PS, which is about 9 kilometers from our village if one takes the direct route. But we were so afraid of the tyranny of the accused persons. On the advice of my father, I took a cross-country route for which there was a delay in reaching the police station. I left my house at about 5 a.m. of the morning.
The fire was lost
After a considerable delay, my lord. After
What-
about 14 hours.
delay.
After a considerable delay of
What-
about 14 hours.
14 hours.
Hmm.
14 hour delay is explained.
Explain.
He has to take a circuitous route because he was
father-
afraid.
The father.
That is what he says.
Yes, my lord, the father warned that they might be guarding in order to harm you.
Yes.
But those persons had just exited their own house, and they had not harmed anybody by them.
See, it was so scary a situation. All of
My
you
lord.
entered inside the house
My lord.
and threatened and.
So he took a circuitous route which was 50 kilometers and reached
This-
on the next
anyway,
morning.
14 hours delay. Huh?
My lord.
14 hours. It is
I left
explained anyway. Anyway, yes.
I
Next.
left my house at about 5 a.m. of the morning following the night of occurrence, and then I reached village Kasimpur, which is at a distance of about 4 kilometers from my village. From Kasimpur, I then went to Asurali, which is at a distance of about 8 kilometers from Kasimpur. After waiting for about half an hour at Asurali, I boarded a bus which brought me to Bhadrak, which is at a distance of about 15 to 20 kilometers from Asurali. After alighting from that bus, I waited at Bhadrak for about 15 to 20 minutes, and then I went to Tihidi PS in a trekker from Bhadrak. Distance between Tihidi and Bhadrak would be about 15 to 20 kilometers. I reached Tihidi at about 4 p.m. or 5 p.m. and then I submitted this written report, Exit 6.
See, she has to take so circuitous route to reach there, taking different mode of transportations. So the delay is
Not
explained.
to protect himself from the persons who had just exited the house without harming anybody.
Delay is well explained. Forget it there. Delay is immaterial.
Right.
Next, come to the next point. Yes.
Then I submitted this written report, Exhibit 6, which was written to my dictation by a friend of mine whose name I do not remember, but he wrote it in my presence. I delivered Exhibit 6 written report to a constable of the police station. Since there was no sub-inspector or any other police officer available at the DPS, after delivering Exhibit 6 to the constable, I proceeded to Chandbali to inform the circle inspector. I reached Chandbali at about 7:30 or 8 p.m. I delivered a duplicate copy of Exhibit 6 to a constable at Chandbali police station for being delivered to the circle inspector. I then returned back home. MOs 1 and 2, mosquito net, MOs 3.
All these are the MOs. Yes.
My lord.
Keep it. Next. I did not mention some of the item properties and so on. So what is the recovery? Who is the witness to the recovery? What is recovered from whom?
My lord, nothing was recovered except certain household articles were identified in the TI parade. TI parade, it was identified by PW7. Only he participated in the TI.
Who is the witness to the recovery?
Without 4,
Four.
without 9,
9. Let us see 9.
4,
What
6 and 9. These are the seizure witnesses.
Caesar, my lord.
Come to 9.
9, my lord.
Yes. Seizure witness, na?
Police has seized Dekchi. Material object 7 was in my presence from the house of accused Kasi Tiadi and Rabbi Tiadi, who are accused present in the dock.
Kasi Tiadi, Rabi Tiadi, who?
Capture is the
A
sticks. AC.
six and Rabi?
Robin the accused saying.
Huh?
He was not convicted.
Rabi is not.
No.
Not convicted.
Robin and Cassie both are brothers. So same room with
Okay. A5, huh? He's A5.
A6.
A6.
One Dekchi was recovered.
One Dekchi is recovered. Okay. And next, the police also sees broken trunks, etc.
In all the articles those were seized, only one had an identifying mark, which was a lota, which had an inscription of Bayani, which is the my lord, that is the only item which had any kind of identifying mark.
Yes. Let us see 4 then.
Oh, yes.
Let us see 4. Come to 4, madam. Who is 3? 3 is one of the witness. One of the eyewitness.
Yes.
Yes, sir.
3. Okay, let us see
4.
4 first.
Yes, ma'am. A bucket, one can, one bed sheet, and some boiled paddy.
From Nagpur, the appellant number 4.
Cannot identify those properties due to lapse of time. Police had prepared a seizure list, which I have attested. Exhibit 1 is my signature
You have
thereon.
to see the seizure list, not that everything in the witness will describe what is recovered. You have to see the seizure list. You have to take me to seizure list. What exactly is seized? And in my presence, dekchis, thalis, tolas, glasses, and bucket, etc. recovered. If you see PW4, in the cross examination, he gives the detail of the necklace is recovered from whom? Because the informant says that necklace was stolen.
A lot of gold and silver ornaments,
It's
and a
recovered
lot
from whom? Not the dekchis and
not recovered.
plates,
Yeah.
thalis and all. What kind of
Gold and
recovery?
silver was not recovered, my lord.
Yes, Mr. Das.
Yes, sir. So ସେଗୁଡା ଖାଲି ମାନେ household ଜିନିଷ
Only household items, my lord.
How will you relate it to the dacoity?
My lord, only one has an identifying mark, which is a lot.
How will you relate? See, what was stolen? See, it is a case of dacoity.
Yes, sir.
What was stolen? The informant says that the necklace and the golden
Lot of
jewelries and everything is stolen.
Yes, sir.
What? Nothing is recovered from any one of them. There is no TI period.
there was a TI period, my lord.
TI period of the articles.
Yes.
Yes, Your Worship.
TI period was
Can we see-
Articles.
Yes,
Eight.
can you see page 32, Your Worship?
30
32, para 24.
judgment.
Yes, Your Worship. PW8 as the judicial
PW8.
magistrate
My
at
lord,
Bhadrap who conducted the
Yes.
TI period and deposed that the suspected articles were mixed up with the other 3 sets of similar articles in which PW7 was
Para,
able to
para, para
identify
24 you are reading?
24.
24, yes.
Yes, sir.
Hmm. Judicial magistrate Bhadrakur shown. So TI period was conducted.
Yes, sir. PW8 was the judicial magistrate at Bhadrap who conducted the TI period and deposed that the suspected articles are mixed up with the other 3 sets of similar articles in which PW7 was able to identify the suspected articles. One brass lota was recovered from the possession of accused Bhavagray Panda in which the name of Bayan was inscribed. PW3 in our evidence are stated to have brought to the same while the she came to the house of her husband. Therefore, the identity of the suspected articles is quite established beyond all reasonable doubt, which was seized from
Because of
the,
this lota, brass lota.
yes, sir.
Well,
All the
this is the only
persons are
the only item that has any kind of inscription,
Identified.
identifying mark, that is the lota.
Because what is scribed there is Bayani.
Yes,
That
my
is
lord,
described
that
as
is the
lota.
name of the maternal grandmother of PW3, but is also the name of the sister of appellant number 1. Is a common name in village circles, my lord. My lord, all the items that were identified in the TI period,
the sister nada same rule.
judgment আছে যেটা acquittal judgment.
Show me that part. Obviously, see, initially, all of them were acquitted. In the revision, it was remanded back thereafter. So that acquittal judgment has some reasoning.
Yes.
Let us see that acquittal
Please.
judgment. If it has a better reasoning than the reasoning given by the judge after conviction, I'll go by that acquittal judgment.
My lord, the reason is
Something there.
Show me the revision.
underlying-
Show me the revision judgment. Why it was remanded? Once somebody is acquitted, why it was remanded? What is the reasoning of remand?
See that.
my lord, may I please read?
Show me that
My lord.
revision order.
This revision.
It is there in the paper.
Must be, my lord.
Just take it up.
Wait,
Must be there. Just check.
wait.
Revision file preferred here in this court. Just take it up. Must be part of the record.
Criminal revision, you have also kindly see 119 of the
Paper book.
TCR.
119.
The digital copy.
Digital copy. Yes.
My lord,
Yes.
in the revision order, my lord, the revision was preferred by the
1 minute.
my lord.
119 कहाँ है अभी? नहीं. Good treatment, good treatment. Wait, 119, huh?
Yes, sir. Criminal revision number 579 of 1985.
No, it's not there. Just check it up.
TCR.
Check there.
8 weeks of also there.
This. Yes, I got it. I got it.
11 for it.
I got it now. Let us see. Let us see. Yes. Let us see. Read it out.
My lord,
What is the reasoning given?
reasoning, my lord.
These are facts in
Yes.
this paragraph.
My lord, in the
Come to para 4. Come to para 4.
para 4, my lord.
Learned Sessions just took the view that
Yes. The FIR in the case was the outcome of consultation with legal advisors, and the allegations made in the FIR were not voluntary, and hence the whole case was doubtful. Besides this finding, the learned sessions judge also held that the details about the overt acts of the miscreants at the time of commission of the alleged dacoity had not been mentioned in the FIR and also before the IO. My lord, the mohrir of an advocate has scribed the FIR. My lord, the FIR is a detailed document saying this thing cost this much, this thing. There's a whole list. And some 43,000 something rupees worth of goods has been looted. That is the allegation, my lord. And it's replete with, my lord, after it has been filed after due discussion, my lord, with the advocate. He has consulted an advocate before filing the...
advocates are meant for that only.
No, my lord, that automatically...
Something happens, he goes to advocate for taking advice what is wrong.
Before the FIR is filed, the FIR is not supposed to be a encyclopedic delineation of what the
That's
fact
right,
is. It's
but-
supposed to be...
Consulting a lawyer
Yes. My lord,
before
and
registration of FIR, what is the illegality in it?
my lord, if I can continue reading the PW7, my lord. First, he says that I don't know any Ajayanand Mahapatra. I have not written, it was not written by any Mohrir, and I have not consulted any lawyer. After it, he has admitted later on that I have done it. That itself shows that the whole thing is dubious.
Let us read. Huh?
My lord.
Some articles said to have
Articles that
stolen.
have been stolen were also not mentioned in the FIR, and it was a doubtful feature in the case. The learned sessions judge further held that although the allegation was that the miscreant snatched away the earrings from the ear of Pushpalata Mishra PW1 and Pakan Mishra PW3, no injury was found in the ears of these ladies and hence the allegation was improbable. The learned session judge also held that the injuries sustained by the witnesses were simple in nature, and hence the allegation that in due course of dacoity some of the culprits inflicted the injuries was doubtful. And the learned session judge also disbelieved the identification of the properties and drew adverse inference for non-examination of the co-villagers. And these circumstances, the accused persons were acquitted. My lord, there is one grievous injury allegation is there that he was stabbed on the in the FIR it is right side of the chest and in the deposition is the left side of the chest. My lord, if we come to the medical evidence, my lord, the doctor says that there is a linear scratch which could have been caused by a needle or the pointed end of a knife. There is no stab wound, my lord.
And that part of the evidence of PDF, the informant is not corroborated.
And my lord, the doctor specifically states that it could be self-inflicted. And my lord, then the
There is
Banyan,
no injury caused to these two ladies.
no injury on
Where
the ears.
the
My lord,
earrings were
this person, the father of the informant, he was not examined on the ground that he had lost mental balance after this incident. But the doctor examined him, nothing, he was in perfect condition. I also stated that he is in perfect mental condition. And he is the person who should say what gold and silver articles are actually missing, because these people saying it is hearsay, they never knew.
Yes. These are the 5 points
Points.
the trial court, the High Court has flagged
My lord.
from the judgment of acquittal. Okay.
My lord,
Let's see now.
the
Advocate, read the
Yes. The learned advocate for the petitioner argued that the learned session judge has an extreme view of the matter. Although the probability factor is the most important thing in a criminal case, the general principle is that a case has to be judged by taking into consideration the broad probability, and for appreciation of the evidence, taking into consideration the minor details is erroneous, as has been done by the learned sessions judge. The learned advocate for the petitioner is also argued that there is a misreading of the evidence and the evidence as it stands has not been reflected in the judgment. It has been argued that the injuries suffered by the witnesses have not been taken into consideration in its proper perspective, and the appreciation of evidence regarding the identification.
Injury sustained by witnesses.
Yes, my lord, the banyan was never seized, never produced in court also. The witness simply says that I threw it away. Therefore, it was not taken into consideration by the law.
Yes.
It is admitted by PW7 that the FIR was written by Ajayananda Mahapatra, registered clerk of Advocate Biswanath Nayak. Due to this circumstance, the learned session judge made uncalled for remarks by taking the view, I have grave doubt in my mind regarding the voluntary character of the first information report, Exhibit 6, and I am also of the view that the contents of Exhibit 6 FIR are the outcome of consultation with the legal advisor, and legal consultation is to draft the FIR in such a manner that rope must be put around the neck of the enemies of PW7. My lord, there were earlier cases to and fro. A previous enmity is established, my lord, as per their own depositions also, and his family members, and therefore the court should be slow in placing any reliance over the FIR. The above view of the learned session judge is an extreme view. In a criminal case, there is bound to be some exaggeration, misstatements, and also at times untrue statements. This happens because the appreciation of evidence is thoroughly technical, and any witness deposing in court is bound to apprehend that he may make some statement suicidal to the case. Thus, a witness is always under mental pressure while deposing in a court, and on account of that exaggeration, misstatements or untrue statements are bound to occur. If any court wants absolute truth in evidence of a witness, it is just futile, especially at this time. Hence, concession has to be given to exaggerations, untrue statements, and misstatements, and substance of the evidence has to be looked into, and it has to be seen whether the evidence as a whole, in the light of other available materials or records, provokes confidence or not. The court must look to the broad probabilities of the case, and if only minor details are looked into for the appreciation of the evidence, a court is bound to be misled. In this case, the informant Ajay Kumar Mishra has stated, PW7 has stated that the FIR Exhibit 6 was written by one Ajayananda Mahapatra, one of his friends. PW7 does not say the name of the friend in the examination in chief. The fact, however, remains that the FIR was written by another person to the dictation of PW7, and it was not written by PW7.
Then where from the trial court got that it is written by Ajayananda Mahapatra? If he is
Self admits it in the cross-examination,
Cross-
PW7, my lord. In
He
cross,
says in examination chief, he says that
Yes.
it's written by one of my friends.
yes.
And the
I
cross, he says that,
any Ajayanand Mahapatra, he says, but then later he
and the
admits.
cross examination of it also
In,
did not disclose the name of the client.
although questions were asked, and he also went to the extent of saying that he did not know the scribe Ajayananda Mahapatra, which is a blatant falsehood, my lord. Registered clerk of the advocate Biswanath Nayak. Subsequently, however, PW7 admitted that he had gone to court compound at Bhadrak, and on his way to Tihidi, he had consulted advocate Biswanath Nayak, who directed him to meet his registered clerk Ajayanand Mahapatra, and at Tihidi, he met Ajayanand Mahapatra, who scribed the FIR. Thus, PW7 does not completely suppress the fact that he met Ajayanand Mahapatra, who scribed the FIR. He has been given concession because he admitted
He
it
took a
later.
circuitous route to meet the lawyer. Thereafter, the lawyer says that went to Bhadrak. The lawyer says that go and meet my clerk. Then he comes to Tikidi, whatever that is.
Sir, in the manner of a catalog, my lord.
Tikidi. Then he took that Ajayanand Mahapatra to the police station and scribed the FIR. So therefore, the trial court says this is consulted, and it is framed basically. Yes.
Owing to previous enmity also, my lord. PW7 has stated that he had consulted advocate Shri Biswanath Nayak, but there is nothing in the evidence to show that the consultation was with regard to the case. In any case, the advocate cannot create the facts. The facts are to be stated by the aggrieved person, and the advocate may modulate the fact to some extent. However, only because there is some consultation with an advocate, it cannot be said that the basic truth in the FIR is lacking. In any case, it is clear from the evidence that the registered clerk Ajayanand Mahapatra himself did not consult with the advocate Sri Vishwanath Nayak before writing the FIR. PW7 has also asserted that the FIR as written to his dictation, thus the FIR has been written with the instruction of PW7, who also asserts the correctness of the contents. In these circumstances, there may be scope to apprehend that the FIR may have contained some exaggerations, and hence caution has to be observed while accepting the contents of the FIR. For this, however, it is very difficult to say that the basic fact that there was a dacoity in the house of PW7 and some miscreants forcibly entered into the house and took away the valuables are absolutely false and imaginary. In these circumstances, the observation of the learned session judge that the voluntary character of the FIR is doubtful and that the contents of the FIR are outcome of legal consultation and that the FIR has been drafted with just a view to rope inimical persons must be said to be very extreme view. In para 7 of the judgment, the learned sessions judge has stated that some omissions were found in the statement made by the IO before the IO, and on account of those omissions, the learned sessions judge has taken the view, in my opinion, these are material contradictions affecting the substratum of the prosecution case. An omission is not always a contradiction. In a dacoity, when a number of miscreants are involved and they do overt acts at different parts of the place of occurrence, and it is not possible for every witness to observe every act of the miscreants. In such circumstances, if one witness makes an omission regarding a particular act, it cannot be said that part of the evidence is either false or doubtful, even if other witnesses have testified to that effect. Of course, the statements of other witnesses have to be judged in the yardstick of probability. It may also be said that omission of a particular fact, if material, may throw doubts on the fact. Facts only, and unless that fact goes to the very root of the matter, and apart from that fact, the other facts which provokes confidence are sufficient to make out the offense, then the offense can be said to have been proved. The approach of the court must be like that. In para 7 of the judgment, the learned sessions judge has mentioned certain omissions. Even if those omissions are ignored completely, still the offences are under sections 457 and 395 IPC can be made out, provided the bundle of facts apart from those omissions are sufficient to establish the offences. To be more specific, it may be stated that omissions stated by learned sessions judge in para 7, even if ignored, do not rule out the facts that some miscreants entered into the house of the informant at night and they committed certain overt acts. If this fact is proved, at least the offense under 457 can be said to have been proved, and the dacoity may not be proved. Attempt to dacoity can also be proved. In any case, it appears that even though one witness had made some omissions in his statement before the IO, other witnesses have not made such omission, and the evidence of each of the witnesses has to be judged on its own merit. However, all depend upon the broader probabilities of the case and the evidence as a whole. The learned session judge has disbelieved the properties MOs 1 to 15 or some of them to be stolen properties, as those properties have not been mentioned in the FIR. The learned session judge on one hand disbelieved the FIR in toto, and on the other hand compared the statements in the FIR with the statements of the witnesses in court, and in view of the omissions of such some statements in the FIR, disbelieved the statements of the witnesses. This approach does not appear to be proper. The properties have been identified by the witnesses in the court. The learned session judge has held that the properties identified by PWs 1 and 3 in the court are of no avail, as the said witnesses were not called to the TI parade. Only PW 7 had participated in the TI parade. In the circumstances of the case, this finding of the learned session judge is erroneous. The properties exhibited in the case are the properties of daily use, and those are utensils, bedsheet, odni, mosquito net, etc. PW3 has identified MOs3 and by specific marks, and she has stated that she could identify the other articles as it was being used by her. Thus, PW3 knew the articles from before, and hence it was not necessary for her to identify the same in the TI parade.
Yes.
In such circumstances, it was necessary confidence.
By,
In this,
by the way, what is the sentence awarded?
my lord,
Sentence?
7 years for 395 and 6 months for 457 to run concurrently.
Undergone period?
I'm
What is the undergone period? Just because the High Court, while remanding, has given a reasoning judgment.
of course, my lord, that order is not under challenge here, but I'm only bringing it up to show bias. My lord, the entire thing, my lord, the court says that 457 can be made out without dacoity being proved or any intention to commit dacoity being proved, and it is an nominal. I'll just read out one or two paras
From
the revision order, my lord, itself. My lord, the scope of revision is very limited. The state had not preferred revision.
I'm not tasting that judgment at all.
Yes, my lord, it is not under challenge.
You should have challenged that why you allowed it to,
not under
allowed
challenge.
it to remain.
My lord, it is not under challenge at this point, my lord. I'm just bringing it up only to show bias. My lord, each of the facts has been gone into in vivid detail, and a reasoning, a straitjacket, virtually a straitjacket has been provided. And deferring to this honorable court, my lord, the second conviction judgment, that is completely, my lord, summarily done in order to convict. Because in this, my lord, what is erroneous here is based on probabilities, broader probabilities, my lord, that is in my humble
Probabilities are there in
Yes.
revision judgment. And what you are trying to say is the after remand, the sessions court has simply gone by the observation made by
yes,
the revision
my
court.
lord, my lord.
That's what you are saying.
Although the order was specifically that it is remitted back to the sessions court to
Without being without
Yes.
being influenced, you do it.
Yes,
That is always
case was to be decided afresh, which has not been done. Mostly, summarily, it has been done. My lord, and the revision order itself, my lord, it goes deep into the facts and gives a reasoning for each, and basically tells the lower court what is wrong and how to go about it. Which, although it is not my place to say it here, but it was perhaps in my humble submission, it was wrong.
What do you want?
My lord, the scope of the revision as it is to correct something that is incorrect.
See, you should have challenged that.
Yes, my lord.
How can I correct it? I'm not sitting
No, my lord, it
appeal over that judgment.
nothing can be done then. I accept, my lord. No, only to show bias, my lord, nothing else. And any case,
Don't
my
use the expression bias. Use the expression prejudice.
yes, prejudice, my lord.
Its bias is against why should a judge will be biased against you?
My lord. My lord, the lower court have in
Where
deference to this
after this court remanded it back, the sessions court got prejudiced by the observation made by the revisional court
yes.
independently without applying mind.
Yes.
He is basically reproduced whatever the reasoning given by the revisional court and convicted.
Yes, my lord.
That's what your whole case.
My lord, in any case, my lord, I'd like to argue on the facts also. In order to establish an acquittal, my lord, I'll try to show that the conviction order itself is wrong, regardless of the revision, the whole thing.
No, that's just, I wanted to know whether
yes.
it was simply remanded because the acquittal order is reversed.
Yes.
So there must be some reasoning. Then the revisional court has given some reasoning, maybe wrong, whatever, and it remanded it back. And once it is remanded back, the trial court is bound to be, because see, all these observations are coming from the facts. Either you read this way or that way. So anybody will be reading it, then it's bound to be somehow prejudiced.
Although an order of acquittal is not likely to be set aside, but in this case, my lord, it has
that
been.
You should have challenged that order.
It should happen. It should happen, my lord.
You didn't.
At this stage, it is no longer relevant. Yes.
Allowed it to happen. That's
yes,
the
my
problem.
lord.
What is the period undergone? Just see. Because these people were in their late 20s and the early 30s. In 1982,
Yes, sir.
this incident happened in 1982. Mm. Just see, because it's a dacoity, and all of them must be in their
Also,
late.
injuries are also there.
Huh?
Injuries are also there. People fight. The doctor is also.
That we will go into.
We will
Just
go
tell me the period undergone, because
But there is a bail bond 22/11/1982.
82. Yeah, then they were on bail throughout.
hmm?
Then they were on bail throughout. 82.
When?
Like that.
Bail they were actually throughout.
No, the see incident happened when?
Incident was in 82 only, my lord.
No, incident, date of incident and date of the bail and all.
Date
that.
of occurrence is 12
Proceeding
10
just-
82, my lord.
Just see the proceeding.
मुझे कुछ नहीं पाएंगे।
The proceeding dated 25/9/90 of this court says that they were on bail in 1982, since 1982. Period undergone may be very, very less. Yes, when is the impugn order? Impugn order is dated?
You know, see, judgment date.
Impugn order dated?
Judgment date.
Judgment date. Conviction.
Hmm.
My lord, 7/8/1990.
7/8,
1990.
1990.
Yes, my lord.
7/8. 25/9 they got the bail here. 7/8 to 25.
Very
Right.
late.
About a month. Month or little more than month. And it says that they were on bail during trial.
Judgment date.
Because there's a bail bond during 1982 also there.
That's right. When see the charge sheet when see the charge sheet when they were arrested.
You have to be page 30 also.
Check it out when they were arrested. Whatever the period undergone, maybe a couple of months only.
Yes, my lord.
Yes, sir.
Because the order says that since 1982 they were on bail.
Mm.
So therefore, after conviction, this court also granted bail on that ground. They were
Right.
on bail throughout their trial. So therefore, the 1 month or 2 months
Yes, sir.
can't be a case of undergone also. I can't do that. Either acquittal or conviction.
Lord, if you if I'm permitted, I'll try to convince the court
Yes,
that
yes,
it
of
is a
course,
case of
of
acquittal.
course.
My lord, in this case, there was.
Have you prepared any note, madam?
Yes, my lord, I have already submitted.
Submitted?
Yes, my lord.
Note is there?
Yes, my lord.
Yes, one note is there. Yeah. Okay. This 16 paragraph note, the note which you have given,
Yes, my lord.
the 16 paragraphs.
Yes, my lord. Yes, my
4
lord.
pages,
Yes, my lord.
isn't it?
Yes, my lord.
7 to 9, 20, 24 you have
Yes,
given.
my lord.
Okay. Let us see that. Come to your written note.
My lord, I have addressed the delay in lodging FIR. In the delay in lodging FIR and the taking of a 50-kilometer route, which was unnecessary. In the view of that, the person's
What was the distance between the police station and the incident?
7 or 8 kilometers, my lord.
8 kilometers.
Otherwise, yes.
But he has taken a circuitous route.
In order to consult with an advocate and get the
Went to Bhadrak
yes,
from Tihdi and
yes, my lord.
okay.
Which caused the delay.
That's what first paragraph is.
Yes, my lord.
First paragraph. Next.
And I have also, my lord, I have also addressed that it was the FIR was made out after consultation with lawyer, which renders it suspicious, my lord.
Delay. Yes.
And it is also in the manner of a catalog, my lord. If my lord will glance at the FIR, the items are written and it has been itemized and the prices have been given and conclusion of 40.
Can you show me the FIR?
Yes, my lord.
If we are in page number 62 years.
Paper book?
Paper book, yes.
Perhaps,
Yes. Page 62. Yes.
no, it is perhaps impossible to remember that many items in exact sequence and with the prices attached, unless it was.
Yes, paid to the lawyer will apply his mind, obviously.
My lord.
Yes. Let us see what.
My lord, then I have addressed that there was previous enmity which has been also admitted.
Go one by one, madam.
Yes, my lord.
It is 7 years. FIR, what do you want to show? It's very exhaustive FIR. Where do
Yes.
you say that ସୁନାର ହାର ନୂଆ ବୋଉଙ୍କର ବାପାଘର ଯୌତୁକ ଦେଇଥିବା ସୁନାର ତାବିଜ ହାର ପୁଅଟା?
Third page of the FIR. Third and fourth page, my lord.
Yes, read it.
ସୁନାର ହାର ନୂଆ ବୋଉଙ୍କ ବାପ ଘର ଯୌତୁକ ଦେଇଥିବା 2 ଗୋଟା ଆନୁମାନିକ ମୂଲ୍ୟ 2400 ଟଙ୍କା, 2 ସୁନାର ତାବିଜ ହାର, 17ଟା ତାବିଜ.
Then he gives the valuation
Valuation of everything, my lord. And none of the silver and gold articles were recovered.
ବିଜୟ କୁମାର ମିଶ୍ରଙ୍କ ଠାରେ ହାତରେ ପିନ୍ଧିଥିବା ମୁଦି, ନୂଆ ପିନ୍ଧୁଥିବା କାନର,
ଚାରିପଟ ସୁନା ମାଙ୍କି, ଗୋଟେ ପଟ ସୁନା. Perhaps it's the English.
କଂସାର 3 ପଟ ଥାଳି,
Yes, ma'am.
ପିତ୍ତଳ ଗରା. All these things are recovered.
Nothing was recovered, my lord. All the things that have been recovered only in court, and the TI parade, only PW7 participated, the informant participated in the TI parade, and he has identified the inner garments of his sisters-in-law also. My lord, saya vaya, everything he has identified.
ଘର ଲୋକ ଟୋଟାଲ ଜାଣିଛି ନା
ଭାଉଜର.
ଭାଉଜର ହେଲା
But what is recovered? କଂସା note.
Well, that has also been considered by the lower court in granting acquittal, that how he was able to identify the inner garments of the sisters-in-law.
And then out of all the list which has been given,
Yes, my lord.
only the number 10, just see number 10, some part of number 10, the items were recovered according to prosecution. Just see number 10. ପ୍ରଭାକର ବାରିକ ସୋନସୋ ବନ୍ଧକ ଦେଇଥିବା କଂସାର 3 ପଟ ଥାଳି
Yes, my lord.
ପିତ୍ତଳ ଗରା
Pittala gora,
ଗୋଟେ
gotte,
କଂସା
lota.
ଲୋଟା
That lota was recovered, my lord.
ଗୋଟେ yes କଂସା ତାଟିଆ ଗୋଟେ ପିତ୍ତଳ କୁଣ୍ଡ 2 ପଟ ପିତ୍ତଳ ମାଠିଆ. All these things appears to have been recovered according to them.
According to the in court, they have recovered some. They have identified certain articles that this is ours.
Yes.
Not in the TI period, my lord.
Not in the
Not in the TI period. In the TI period, also some articles were identified by PW7, including some clothing, the garments and everything. My lord, the main allegation that the granary was ransacked, almost 2/3 of the granary was lifted, my lord, which amounts to 40 quintals of molasses and 20 bharan of paddy. It is impossible for 6 persons to lift.
30 জন আসছেন কହୁଛନ୍ତି 6 ଜଣଙ୍କ ନାଁଟା କହିପାରୁନି
Even if my lord, your lordship considers that 25 to 30 persons as per the FIR, including women, all are co-villagers, my lord. They are not professional dacoits, and this comes to, my lord, about 7,200 kilos of paddy.
according to you it looks like little
It is
more exaggerated.
My lord, 40 quintals of molasses and 20 bharan of paddy, my lord. I have found out the quantification of that. 1 bharan is 80 goni and 1 goni is 4.5 kg of paddy. My lord, it comes to 20 bharan, therefore translates to 7,200 kilos of paddy plus 40 quintals of molasses. 11,200 kgs of, my lord, molasses and paddy were lifted. 11,200 kgs. That is the allegation, my lord. My lord, that no, my lord, that is in the FIR.
What he says, because that is the reason you have to see the context also.
Yes.
And if incident happens, instead of going to the police station straight away, he takes a circuitous route of 50 kilometers.
Because of afraid of the
And-
person sir also jo
ନାଇଁ, afraid-
ପଶି ପାରୁଛନ୍ତି sir ସେ ବାହାରେ
ବାହାରିଲେ ମାରିବେ।
Then you will go to Bhadrak, afraid.
sir ଲୁଚି ଲୁଚି ବୁଲି ଆସି ମତେ କେହି ଟ୍ରେସ୍ କରିପାରିବେନି
My lord, those people were there in the house. They did not harm.
That's one way of looking
sir
at it.
ଗୋଟେ
but-
ଦେଖନ୍ତୁ sir
So-
sir
so-
you also
so
kindly
what-
kindly suppose ମୋର ନା ଗୋଟେ ଏଠି କାହାର ଝଗଡା ହବ ସାର୍ ମୁଁ ଲୁଚିକି ଏପଟ ସାଇଡ୍ ଯିବି ନା ମୁଁ ସେଇ ବାଟରେ ଯିବି ଯୋଉଥିରେ ମତେ ଫେରା
ସେଇ ବାଟେ ଯିବା ଦରକାର ନାହିଁ କିନ୍ତୁ 50 କିଲୋମିଟର ଯିବା ଦରକାର ନାହିଁ।
ସାର୍ ବାଦାମବାଡି ହେଇକି ମୋର ମୁଁ କନିଆ ଛକ ଘରକୁ ଆସିବି ଚୁପି
I can understand there.
ସେଇପଟେ ସାର୍ ଗଲେ ସାର୍ ଧରିବନି ମତେ
But not 50 kilometers going and you will not go to Barampur.
My lord,
Here.
ସାର୍ କୁଆଡେ ବୁଲିବାନି କି all the persons from Tihidi also. Lawyer Tihidi se jayke amno podi lawyer nu. Same place also.
but he was at that
Yes, sir,
time.
bully
in
wali
the
bhi
court-
as-
Looks like little unusual.
Maybe sir to
My lord, none of the-
but sir डर भी सर गांव लोग डर भी 30 लोग को सर घरे पसिबे हठात राती रे
You are right. You are right.
My lord, my lord, 25 to 30 persons entered the house. My lord, there are many houses in the vicinity. The brother-in-law's house of the brother-in-law of the informant stays 200 cubits away. Nobody turned up, my lord. They have said that we created a halla and everything. Nobody turned up, my lord. The entire 200.
Maybe looking into 30, 40 people, they got scared that nobody knows what happened.
All of them are co-villagers, my lord. They are not professional dacoits or
These
anything.
are the speculative probabilities.
My lord, then they say
We will see the evidence. What are the
Yes.
evidence
you
which
also
has come out?
see people 1 and 2 mainly the eyewitnesses are
Let us see. This is we read PW7. We read already.
yes, ma'am.
And now let us go. You have made the point regarding the delay part.
Quantum of the paddy.
Delay part quantum you have not written in the written note.
My lord, it is in in para 5, my lord.
Para?
Para 5, my lord. Paddy and molasses amount to 11,200 kgs, my lord.
Para 5. Yes.
And if
400 kg of molasses and 20.
400, my lord, that is my mistake. It is 4,000, my lord. 40 quintals has been written. My mistake, my lord. 4,000. that is.
7,200 kg of paddy.
Yes, a total of 11,200
11,000.
kgs. How it is possible that these many co-villagers, not professional dacoits, they did not even come with bags. They PWs themselves say they did not come with bags. They took our bags and they took away everything. How it is even possible?
Whether there is any, there any vehicle or anything of
No vehicle has been mentioned either by the IO or by the PWs, and the light has been the light source has been said to be torches and debris, my lord. And the debris was also taken from the house, my lord. Lord, one more point, my lord. The IO has said that from the granary door was broken, was damaged, and there was a trail of paddy from the granary to the gate. 50 kgs of grain was, my lord, strewn about in the courtyard. But beyond the gate, there is nothing, my lord. It shows that it was deliberately planted.
ଗାଡି ଫାଡି ଆଣିଛୁ ନିଶ୍ଚୟ ନେଇଯାଇଥିବ ସେମାନେ ଯୋଉ ଘରେ ବାନ୍ଧିଦେଲେ ବୋଲି ଦେଖିନାହାନ୍ତି ବାହାରେ
ଗାଡି ନେଇକି ଆସିଥିଲେ 30 ଜଣ
ସାଇକେଲ ଫାଇକେଲ ନେଇକି
30 ଜଣ
ଆସିଥିଲେ
both of you are arguing as if you were there. Both of you were eyewitnesses.
apologies.
This happened that time. Tell
Apologies.
me, show me from evidence. This happened as if both of you were there and you have seen the incident. I don't know whether you were born at that time or not.
You know, said regarding bill of affair,
Let us see the evidence now. Huh?
Yes, sir.
My lord.
Let us see the evidence. On the basis of evidence, we can analyze.
Yes, sir.
Yes. PW1, madam.
My lord. A dacoity had been committed in my house 2 years 11 months ago in the month of Ashvina on the night of a particular Tuesday. On the night of occurrence, after dinner, I, along with the inmates of my house, retired to bed. I was sleeping on a bench which was placed in an open space, which is a passage leading to the inner apartment of my house from the bari door. At about 10 p.m. of the night of occurrence, when I was sleeping, my son Vijay Mishra and myself heard a heavy knocking sound on my by my bari door. My lord, this is the mother of the informant.
Hmm.
And the son she's talking about
This
is the
witness
brother of
mother of the
yes.
Pushpalata.
My
Pushpalata.
Pushpalata.
She was also injured.
She is injured?
Yes, sir.
Injured eyewitness. Huh?
Yes.
My son got up and asked me to open the door and find out who was knocking at our door. My husband Jagabandhu forbade us to not open the door. I called out and asked the persons knocking at my door to disclose their identity. One of them, namely accused Bhabha Panda, identified.
This is Baba Panda is again
Unit number 1.
PW1. Sorry, A1. A1.
He
Yes.
replied Manus. I could identify Bhabha Panda by his voice. I then questioned accused Bhabha as to why he was breaking my door. In reply thereto, Bhabha said that Bijay Babu had sent him and others to take rupees 500 from us, which would be utilized by them to drink liquor. Since I did not open the door, the miscreants broke open the door and effected their entry into my house. About 25 to 30 persons entered into my house. The miscreants were armed with lathis, knives, etc. Some of them also held torchlights and they were being flashed. Accused Bhabha Panda and accused Bengali alias Surendra Tiadi identified.
वो Bengali.
Again.
ठीक है?
as
Bengali is
Bengali is A2.
2, my lord.
A2. Yes.
Accused Bhabha assaulted me with lathi which struck on my left scapula. Some of the miscreants, including Bhabha and Bengali, dragged me and my husband to the courtyard, and my husband was tied by them to a pole fixed in the courtyard.
Husband was tied.
Yes, my lord. The husband has not been examined.
Husband was tied.
Yes.
But this
But the doctor says no.
this tied thing has not been said by PW7.
Others have not.
Yes. Yes.
Accused Bengali pointed a knife at my husband and asked my husband to disclose the place of concealment of our valuables. When I protested for such misbehavior towards my husband, accused Bhabha Panda snatched a pair of earrings which were worn by me in both the ears. My lord, no injury is present in the ears.
Snatched the earrings, pair of earrings.
Accused Bhabha also removed a silver necklace. In the FIR, it has been mentioned as golden necklace from the neck and from my neck, which I had worn. When my son Bijay protested as to why his father and mother were being assaulted, accused Bengali pierced his knife into the left side chest of my son Bijay. This clearly alleges a stab wound, my lord.
Yes.
It was stabbed. When my daughter-in-law Pakan Mishra raised an objection, accused Bhabha, Bengali, Balaram Panda, Kasinath Tiadi went near my daughter-in-law.
Bhabha is A1, A2, Balram is?
Balaram Kasinath.
Balaram is 5. Kathy is
A5.
6.
A5, huh? A5, Kashi is 6.
6. Witness identifies accused Balram and Kashinath. Accused Bhaba snatched one earring from my daughter-in-law, who also requested the accused person not to touch her body as she would voluntarily surrender the ornaments worn by her before them. And so saying, my daughter-in-law took out the second earring and the necklace
He
worn by
took
her.
out, there is no chance of going.
One was snatched and this other was taken out by her. Both the earrings and the necklace were of gold. My daughter-in-law delivered the earring and the necklace to accused Bhaba, being afraid of the criminal force already used against her. Since my daughter-in-law was wearing a good sari which may be valuable, accused Bengali tried to pull out that sari, and being afraid, my daughter-in-law wore a torn sari and delivered the good sari to the accused Bengali. Thereafter, the miscreants took my husband, myself, Vijay, another son, my daughter-in-law, Devendra, my grandson, into the bedroom of Vijay and confined us in that room. At that time, 4 persons guarded us and they were accused Nakul Nahak,
Yes.
Gayatri, Bhaba Panda,
Nakul is A,
Gayatri,
Nakul is A4.
A4.
A4 and Gaya.
Gayatri এটা বলছে
Not,
Gaya.
it's not been convicted. No, no.
Okay.
Bhaba Panda.
Bhaba Panda.
Baba Panda A1. Everybody has taken the name of A1 and A Bengali. A1 Bengali and A. They have taken the name.
One,
Both the informant.
4.
And this Balaram A5 and A6 has only they were there.
Tripathi was diary.
No, huh?
Gayatri Tripathi, appellant number 2.
Oh,
Gayatri
three, three.
Tripathi.
Appellant
A2,
three.
huh?
Appellant number 3.
Appellant 3.
Right. Huh?
Yes.
So overtake is attributed to Bhabo and Bengali.
Mostly Bhaba and Bengali.
Yes, next.
Rest of the miscreants removed gold and silver ornaments, utensils such as bell metal, konsa, thali, ginna, etc. They also removed gora and mantia. They also removed our clothes such as dhotis, saris, etc. and bedsheet, mosquito net. They also removed an aluminium handi and a bucket. They also broke open the door of my granary and removed paddy which had been stored in the granary. They also removed 2 watches belonging to Vijay and Ajay. Besides the accused person named above, others who were also present with them in the dock had also entered my house. Besides the persons guarding us, remaining accused persons were removing the aforesaid properties from my house. I know each of the accused present in the court by name and face, as they are my co-villagers. The witness correctly names and identifies accused Babaji Naik, Rabi Tihari, Pahala.
They are the accused person. How many of them identified? Babaji is A. Just take it up.
These names do not.
They are not accused.
Yes, my lord. They have not been convicted, at least, my lord. Nakul Nahak, except the Nakul Nahak.
Hey,
Balram.
why these people were not?
My lord, the FIR was against 13 persons. 16 persons faced trial. All were acquitted, and on second round,
That's right.
6 were convicted.
These people were accused initially or not? Because specific names are taken.
Yes, initially also they were.
1, 2, 3.
ସମସ୍ତେ ଥିଲେ.
এই ନାଁ ଗୁଡାକ ସବୁ ସେ କହିନାହାନ୍ତି ବୋଲି ସେ ସେମାନଙ୍କୁ acquittal କରିଦେଇଛନ୍ତି. Only these 6 persons names are from the Fidel 1, 2 and 1, 2, 3 and 7 also. That's why only 6 persons are there.
No, these 15 persons have been identified. They were there.
Doc. But they are not saying what they did in that.
No, then if that is the case, then there will be only 2%.
No.
The Ponda and that Beguni.
Ponda আছে বেঙ্গলি.
Bhava Ponda and Beguni.
ସେ 4 ଜଣ ଜଗିଲେ ବୋଲି ଏଇ ଯୋଉ 4 ଜଣ your lordship 4 persons and they are bedroom Ajay and confined in the room. At that time 4 persons guarded us and they are Nakkuda, Goyatiyari that expired. Bhava Ponda was one Bengali.
Then okay, then you Bhava Beguli is already there. And
Yes,
at best you can bring Nakulo, 4 of them.
Yes, sir.
At best Nakulo, that he goes, Gaya goes.
ବଳରାମ ଆଉ କାଶୀ ବିଷୟରେ ଉପରେ କହିଦଉ ଏମାନେ ଜଗି ଏମାନେ କରିଛନ୍ତି ପ୍ଲସ୍ ତାପରେ ଜଗିଲେ ତାଙ୍କୁ ଅନ୍ୟ
Some were guarding and some were looting the granary.
ସେଇ ପେଜ ନମ୍ବର 3 ରେ ଯୋଉ ଅଛି ସେଇଟା ଉପରୁ ପ୍ରଶ୍ନ
Balaram, Bengali, Balaram.
Bengali Balram Ponda, Kasinath were near my daughter-in-law, witness identified accused Balram and Kasinath.
Accused Babos received one hearing from the daughter-in-law. They were there anyway. Next, yes, read, madam.
Yes, ma'am. The accused persons named and identified by me were, my lord, page 6.
Yes.
The accused persons named and identified by me were assaulting us and were removing our properties mentioned above. I have been medically examined since I had sustained injuries. About 25 or 30 persons had entered into our house on the night of the occurrence, out of which whom I have named and identified the accused persons present in the court and also the accused Kapil, who is absent today as they are my co-villagers. The remaining miscreants can be identified by myself if I see them, but I cannot name them as they were not my co-villagers. All the 25 or 30 who had entered into my house were removing our properties. It was rainy season. Though my house is situated within the paddy fields, yet I cannot agree with the suggestion that there is no approach road to my house. Our house consists of 3 bedrooms and 1 passage room leading to the southern door. One of the bedroom is occupied by my husband. The second bedroom is occupied by my eldest daughter-in-law Pakan, wife of Purna Mishra, and the third bedroom is occupied by my son Bijay and his wife. Witness volunteers, since wife of Bijay had gone to her father's house, the said bedroom was occupied by Bijay. Ajay and his younger brother Santosh. Ajay and Santosh are unmarried. My son Purna has never visited Haridwar. He serves in Calcutta. He is not a labor contractor. I have 6 sons and they are Purna, Ganesh, Ramesh, Vijay, Ajay, Santosh. Ganesh serves in a company at Haridwar. It is not a fact that Ganesh is a labor contractor. It is not a fact that Narayan Panda and had accompanied Ganesh to Haridwar. I know Narayan Panda. I cannot say whether Narayan is alive or dead. I cannot say where he is now staying. There were about 30 bharan of paddy in my granary. The FIR says 20 bharan and now if it becomes 30. हाँ, 2/3 नहीं ଯାଇଛନ୍ତି କହୁଛନ୍ତି ନା କେତେ ହେଲା କେତେ ହେବ 20 ହେବ 1 bharan is paddy is equated with 4 for chillas about 80 bhanas is equivalent to 40 quintals approximately of good. 40 quintals of good is my lord mentioned were removed from the miscreants from our house. The miscreants were removing paddy from our granary with the help of baskets. It is not possible.
I don't think in the cross-examination anything substantial could be elucidated from the witness. Any relevant part you want to show me from this cross-examination?
My lord, the medical evidence as to the
No, firstly, let us finish this witness. Don't jump here and there.
yes,
Let us see. This witness is over now.
more or less, my lord. My lord, she also says that the son was stabbed. The informant also said that his brother was stabbed.
This witness is over now. Let us see.
My lord, the miscreants were returning with empty bags and baskets when the miscreants first.
I read almost everything, but who is two?
My lord,
Huh?
He is also injured.
Injured eyewitness.
Yes.
my lord, the medical officer is Peter.
He also narrates the same way. Let us see who takes name of whom. Call me my father so. Bhagirathi Bhava Panda identified, huh? Bhava Panda.
Has been identified by almost everybody.
Bhava Panda broke the door and the 20 to 25 people miscreants around with artists also. Bhava Panda asked Bhava Panda again. Bhava Panda. Bengali. Bengali Bhava Panda. Bhava Panda. Nokulo. He is taking Nokulo Balram identified. The first accused Bengali Nokulo Bhava Panda. Nokulo Balram. He doesn't say anything about Kasina. Generally, in this kind of situation, when you go to the police station, police says that you write down what are the things stolen.
Okay.
Generally, they say, and whatever you remember, you keep writing. You don't exactly, you don't know, na? You can't have a verification what is stolen or not.
My lord,
Incident happened, you went there. And generally this happens, you go to police station says that कौन चोरी है लिखो.
my lord,
Then he started narrating things.
my lord, if the allegations
So
are
in that narration, something wrong might have also gone.
exaggerations are there, yes, my
That
lord.
is there.
But my lord, if the allegations are believed, then it is impossible to carry away such amount of such quantum of around
See,
11,000
this is
something.
in writing over enthusiasm,
Yes.
nothing else.
My lord, if they're not the allegations are not believed and the recovery is believed, then nothing was recovered except a lota.
That's a different story. But I'm just
Yes.
thinking.
My lord, at page 8 of the PW 2, my lord.
Accepted there something is there.
No, no.
Accepted now.
No, no, ସେଇଟା କହୁନି ମୁଁ କହୁଛି previous cases were there. my
Yeah,
lord.
Previous cases there, ତାହେଲେ ଏଇଟା ତ proof ସେଇ ରାଗ ରଖିକି ସେମାନେ ଯାଇକି ସେଠି କରୁଛନ୍ତି.
this is double weapon.
Yeah, that is a double-edged sword. We had filed a case against some of the accused persons and the said Vijay Naik prior to the date of present occurrence, alleging that the accused persons, including Vijay Naik, had molested our family members. There was a molestation case pending, and perhaps there were 2 or 3 cases such.
PW3 also says Bhavo Fonda. Bhavo is greetings. Main Bengali and Bhago are the main persons.
Okay.
Bulia Panda is another Bulia Panda.
Gaya Tripathi, that is appellant 3 who is dead now.
Okay. So,
Baliya Panda ki.
what is the one that you find? तो Bengali बोलिए तो open my boxes and remove gold ornaments and some to others.
PW3 gives name.
Yes, sir.
Bahali Panda, Anand Panda, पूरा गांव का सारे का नाम दे दिया भाई. Let's see PW3 para 2. PW3 para 2. 131 page. He gives the name 1, 4, 5, 6, 7, 8, 9, 10, 11. उसके बाद 12, 13, 14. Can it be possible in this kind of incident you take the name of 15 people identified?
See, let's talk about the 15th one. At least paragraph number 1 you will also kindly see.
Bengali, then Badia Panda and Bhabo.
5, 1. Everybody is saying about 5, 1, 2, 5, 4 and 6. Even the 3, those who have died, the person applying number 3 name was also the PW1 uttered the name of the PW3. These 6 persons that they are categorized who did what. In generally, he says 13, 14 people's name, but in these 6 people's, the people 1, 2, and 3 saying that the who are doing the exact overtake of the accused persons also.
PW5 examined Puspalata, PW1.
Yes, sir.
Isn't it? And he finds
Bruise
he
along the
finds
left side of the neck.
one bruise, left side of the neck. But she says it was the earring was pulled.
My lord, there are no such corresponding injuries. মানে ইয়ারে କିଛି ହେଲା ନା ଖାଲି ନେକରେ ହେଇଗଲା?
ଏଇଟା ଟାଣି ଦେଲା ବେଳକୁ ବାକି ଏକ୍ସାକ୍ଟଲି ଅଛି ନେମ୍ ସେ କଣ ଜୋର ଟାଣି ଦେବ କିଛି ଫୋର୍ସଫୁଲ ଟାଣି ତ କେତେ
Well, that is the exact reasoning that has been taken in the revision order. କେମିତି ହେଇଥିବ?
But the injury was simple in nature and
Simple.
was well grown open like that. The age of the injury within 24 to 36 hours prior to the time.
Next page is there is a Vijay Kumar, there is a chest injury.
Yes,
Chest injury, my lord. That is the major assault injury that has been alleged.
By the Bengali.
Bengali.
Appeal number 2.
My lord, in the FIR, they have written, the informant has written that the right side of the chest was stabbed. Everybody has deposed that the left side was stabbed. It has been explained that I was.
They are not, madam. The fact is there is an injury.
Injury.
Yes, my lord.
That is corroborated with medical evidence.
My lord. One linear scratch.
Jagannath also received some injury.
My lord.
Jagannath. Para
J-
3.
Jagab-
Jagabandhu.
Jagabandhu was not examined.
Not even she said the bapatas se pura se the bandi thile phone se tension le pura se. ସବୁଗୁଡାକ injury is 24 hours to 36 hours.
There are some code questions. Cross examination.
My lord, para 5.
He's taken LTI and there is a code question. Yes, madam.
Lord, para.
In such a chaotic situation when many people comes, you can't expect the witnesses to be very precise.
Yes.
This exactly happened,
Very,
that
very,
exactly
very.
happened. That
But,
can't be possible at all.
My lord, the allegation is that knife was pierced into his chest. The banyan was blood soaked. The banyan was never recovered or produced in court, never seized. The banyan was blood soaked. That kind of an allegation is there, my lord. It will amount to 326 at least, my lord. But in this case, the
Simple
doctor
injury.
says there is an abrasion, a scratch only, my lord. My lord, the last paragraph. Possibility, PW.
Last paragraph of
Last paragraph, my lord. Cross examination, my lord.
of the PW
PW 5, my lord. The
5. Okay. Yes.
possibility of possession of injuries mentioned in exhibits 2, 3, and 4 by friendly hands cannot be overruled. Injury number 1, that is the major injury, my lord, cannot be caused with the sharp side of the blade of a knife. Cannot be caused of any size, but it can be caused with the pointed tip of the knife. Earlier also he says that it can be caused by a needle or the pointed tip of knife. No stab injury was ever found. My lord, if this kind of exaggeration is there, then where does
It
it?
looks like a
Your
bit exaggeration.
What can be caused with the pointed tip of the knife?
Yes, needle knife selection, the beginning to be said actually. Scratch. It is a scratch after all. Abrasion is
Most have been caused by children or weapon like needle or a knife having very thin pointed tip.
like needle or knife. It is not a stab injury by any means, my lord. Yes, injury is there. And it could have been caused by friendly hands. It could be self-inflicted, as opined by the doctor.
There was but injury was there.
Yes, injury was there.
What else? It looks like a bit exaggerated narration of the story.
Yes, sir.
But
the
all the three injured witness, why should the injured witnesses and the informant will not be believed?
My
Yes,
lord,
sir.
Contradictions are there in such a situation where a
yes.
chaotic situation is being
Yes.
created, everybody into some action or the other inside the room, and things were stolen, and a terrifying situation is created. That time you don't expect that the witnesses will be very meticulous and particular, precise. This happened, that happened, and this little variation would be there.
My
And because exaggeration would be obviously be there. That's what the revisional court says.
yes.
In such situation, exaggeration will be there. But merely little exaggeration by some witness here and there will not the cause for disbelieving the witnesses. The witnesses are consistent
Yes.
and
Allegations are
consistent,
consistent.
taking the name of at least
Three of the
Bhavaponda and Baliya.
Bengali. My lord, my humble submission is that the allegations are of such nature, dacoity and grievous injury, etc.
What is the minimum sentence prescribed, madam?
395, my lord.
395.
Perhaps a minimum.
395, huh?
Right. Which makes extend to 10 years. You're saying imprisonment for a term which may extend it to 10 years and shall also be liable for fine.
No minimum.
Yes, sir.
Minimum का चाहिए.
395 to punished with imprisonment for life is also there. Whoever commits dacoity shall be punished with imprisonment for life or with requisite imprisonment for a term which may extend to 10 years and shall also be fined, liable to fine.
There's no minimum sentence.
If other accused persons were taken out, only these two people will be there, Bhabbo and Baliya. Then it would be a
Bilkul.
case of theft.
My lord, my humble submission is that the allegations are of such nature, unless they're in a criminal case, my lord, the allegations must be proved beyond reasonable doubt. A dacoity and lurking house trespass, housebreaking by night is not warranted. Such kind of that is my submission, my lord.
No, that's yeah, I'm
Because
just
the recovery has
finding out what there are some. See, I can understand if the recovery would not have been there. The valuable things which has been stolen is not recovered.
no.
Nothing
Only-
of that to recover. But
and the only thing that has an identifying mark.
can you be acquitted only on the ground that witnesses have exaggerated the story?
My lord, the exaggerations are of such nature. If exaggeration, my lord, it could be a concocted story also. They say that they raised halla.
Three witnesses are very consistent in the story.
Consistent as to the allegations, my lord. It
And you just see your FIR. Thereafter, all the witnesses have largely said the same story.
some discrepancies are there, but largely the same story.
Then how will you discard that? And that stood corroborated with the doctor's evidence. Maybe simple injury or whatever injuries are.
My lord, if the if the punishment is reduced to theft and 323, my lord, then there could be a question of probation or something, my lord. But
That's what I'm just wondering.
Yes, my
What
lord.
I'm trying to
My
figure
lord,
out
the,
way.
my lord,
Then-
the oldest.
Because see, this is the incident of 1982.
Yes, my lord.
These people will be must be.
My lord,
in
one
their-
of them is 88, my lord. The oldest one is 88, and the youngest one, who was 18 at that time, he is a senior citizen now, my lord.
Obviously.
Oh, above 60.
So at this stage, sending them for serving
7 years, my
sentence
lord.
is very unhuman kind of situation. So therefore, I'm finding out way. You tell me. Both of you tell me. While maintaining the conviction, reduce the sentence, what could be done? What we can do? Because see, two persons' name are consistently coming.
Yes, my lord.
That is Bhabo and Bolia.
Yes.
Bhabo and Bolia. We can very well say in the same footing, the other people are acquitted. We can acquit all of them. What is the Bhabo and Bolia's age? Just see. Bhabo Bolia. We will can think of convicting them and the rest of the. Bhabo was 26 years.
6 at that.
Bolia was 27. Then now, in 1982.
80, my lord.
Now, you will be
18, 25.
Hmm?
So ଭାବ sir 90 judgment ରେ ଲେଖିଛନ୍ତି 26 ଇଏ 90
ठीक है, 1 year here and there, but what?
ଅପିଲ 90 ରେ ଲେଖିଛନ୍ତି 26 ତାହେଲେ 82 ରୁ କେମିତି ହବ sir ଏଟା ତାହେଲେ ଏଟା ଭୁଲ ଟା ଲେଖିଛନ୍ତି
Huh?
So,
See the, just see the chart sheet. See
ଆଜ୍ଞା
the chart sheet. Somewhere you see.
age is usually reflected whatever is in the judgment.
Ah, just check it up. Huh?
sir 82 ରେ ତାପରେ 26 8 69 ଗୋଟେ
They are also 70.
Around 70,
Around 70. What will you do with these people?
ଗୋଟେ 45
7 years, my lord.
sir
I thought already say hey,
88 now, my lord.
88
years. See about the
And find out in 395, can I give probation?
82 sir ଦେଇଛନ୍ତି ଯୋଉ ଦିନ
Can I give probation? Find out the judgment and tell me immediately.
If 395 is not maintained, then they're.
No.
they-
Suppose if I can, by maintaining the judgment of conviction, if looking into their age, all of them are in 70.
My lord, if the others are acquitted, then 2 people cannot be convicted for 395.
No. What I'm saying is the other proposition. I will not touch the insofar as conviction is concerned,
My lord.
but maintaining everything as it is, looking into their age, all of them are in 70s.
Yes, my
70s.
lord. 70s, 80s.
Can I grant probation?
probation ତ ସେଇଟା
Find out.
ଆଜ୍ଞା
Find out immediately. Huh?
My lord.
I'll just come up.
judgment କିଛି ଅଛି
15.
ତାର
Find out. We will get judgment.
Yes, my lord.
Looking into the age, see the age.
Yes, my lord.
Age, all of them are in 70s.
70 yes.
plus.
80s and.
We will not send them to jail now at this stage. So, but maintaining this, if that doesn't happen, if you can't get judgment, the other thing will happen.
Right.
Okay.
On the last occasion, Lord Sri.
We'll hear it today. At 2 o'clock we come.
If it is possible, Lord Sri.
Let us see. Wait for a minute. What judgment they've got it. Got some judgment? Yes, madam. What is her name? Just put it.
Statute specifically excludes those offenses where life or life imprisonment or death are prescribed, so there are no such judgments.
Have you got some judgment? Note it down. I was just searching there. I got hold of a couple of judgments. Delhi High Court, there is a judgment. That is, I think, just Delhi High Court judgment. Just check it up. And probation of offender section. Section 6, just see. What is the requirement? And 2006 SCC. 6 SCC. This is, I think, 359 page.
Yes, my lord.
Check that judgment. Probation of open. In exceptional circumstances where the situation is such, all the accused persons are crossed 70 and all. In those situations, can it be done or not?
Yeah.
Because we are following the jurisprudence of reformatory jurisprudence, you know. Somebody has to see 40 years. 40 years. 42 years back, something has happened. Anyone of them is less than 20 years?
Yes, my lord. 5. Appellant number 5 was 18.
Bolram Ponda.
18 years.
18 years.
Bolaram. Bolaram can get to the benefit because under section 6.
My lord, but even then it says there's a caveat not with imprisonment for life. 395 carries imprisonment for life.
Carries but not awarded.
Not awarded, my lord. 7 is up.
That's the difference.
My lord.
It doesn't say an offense punishable with imprisonment, but not with the internal trial. Find out some judgment, huh?
Yeah.
And I'll keep it. Keep it for judgment. We'll give further written argument, both of you. I'll just see.
My lord, alternately, even
You on sentence,
yes, my lord.
you give in writing.
On sentence.
On sentence.
My lord.
Huh?
My lord.
So far as the conviction is concerned, you have argued already. I have noted down.
My lord.
And in so far as sentence is concerned, all the areas you cover.
My lord.
You also give.
Yes.
Give it a written note of.
Yes, my lord.
Heard, judgment reserved. Both the counsels undertaken to give give their written note of submission within a period of 1 week.
My lord.
Within a period of 1 week. Huh? Sure. This is the last matter of 1990. We will start 91 now. We will step into 91. 1 year is over. Step
Bless.
90.
So item number 4, your lordship. The report has a copy.
What is the
He
report?
is alive.
Alive. Alive. Teach.
Item number 4, huh?
Yes. Item 6. No, you were selling some parted matter. Who was? Yes. Which one is parted?
Lordship, item 26, Lordship.
What was that?
Lordship, on the last occasion, Lordship directed me to find out the way how 354 is parametrial to 31 XI, Lordship, of ICST Act, Lordship. I find one judgment, Lordship, and one. Also, before going to that judgment, Lordship, I have one ground, Lordship.
26th, na? Item 26, na?
Yes, Lordship. Lordship, the prosecution has not brought any materials in record that accused or petitioner does not belong to SC/ST community. That part has not been admitted in this case, Lordship. No certificate has been.
Recall what?
The first judgment I am referring, Lordship, 2020. Lordship, 2024, 9.
This judgment you are giving?
Yes, Lordship.
2024.
94,
Yes.
OCR.
Which para?
As para particular operative body, Lordship, 12, Lordship. One of the prime ingredients of Section 3
One
of
minute.
SC/ST and Act.
1 minute. Yes. One of the prime ingredient of section 3 of ACST
That
show
victim-
that the victim must have become a member of a
Right.
universal tribe. Okay.
So in order to penalize an accused under Section 3 of SC/ST Act, Lordship, it should be duty of the prosecution to bring materials into the record either through orally or through documentary evidence that victim is a member of SC/ST and the accused is not a member of SC/ST unless and until it is established proved on behalf of the prosecution by bringing materials into record that victim is a member of SC/ST and accused is not a member of SC/ST. No conviction under Section 3(1) XI of SC/ST Act 1989 can be made against accused. On that aspect, the proposition of law has been already been clarified in ratio following decisions. So, 3 decisions are also listed there.
Then these judgments are cited. Huh?
Yes, sir. Another judgment
So
was
it says orally or through documentary evidence,
Yes,
one has to prove.
that has
Yes,
not
sir.
been proven in this case, Lordship.
Hmm.
Now, another judgment I am referring, Lordship, 2024-93 OCR 173, Lordship.
93 was
It is also written in the operative part, Lordship.
1 minute. 93. No, you have given total other judgments.
10, Lordship, para 10.
Huh?
Para 10 of the judgment, Lordship.
No, you have given 2093 was here. Okay. Yes.
Yes, Lordship.
Para
Para 10, Lordship.
yes.
Is already stated, neither the FIR nor the complaint petition, nor even the initial statement of the complainant and statement of the witness examined on his behalf contains a whisper that accused person do not belong to scheduled caste. Obviously, in the absence of any such averment statement, it is not for the court to draw any presumption as regard the caste of the accused person. Thus, this court find that a basic ingredients necessary to constitute the offence under Section 3 of SC/ST Act.
Yes, that is the
Not
necessary.
at all.
Yeah, that's nice.
That's it.
Yes. This is the in similar line you will get many judgments.
Yes, Lordship.
But what is the evidence in your case?
Exhibit 4 is the caste certificate, my lord.
Caste certificate is there.
Yes.
Caste certificate
is
of
there.
victim is there, Lordship. Caste certificate of accused is not there, Lordship.
No. What does it say? Caste certificate of accused is also required.
Lordship, if you will go to, Lordship, you can refer the SC/ST book, Lordship. On this,
All the
section three-
judgments are saying regarding the victim only.
Yes.
Where does it say regarding the accused?
Lordship,
Which one yours? Which
2024-94 OCR 792, Lordship. Go to the Lordship, para 12, Lordship, next
Para
page,
12, wait.
7 page number
Okay.
795, Lordship. It should be duty of the prosecution to bring materials into record either through orally or through documentary evidence. The victim is a member of SC/ST and the accused is not a member of SC/ST. Unless
the accused is not a member of it.
Not a member.
This also you have to bring.
that also proved. Lordship, that has not been proved. If you Lordship, if you peruse Lordship, Section 3 of SC/ST Act 1989.
एक minute. Victim and accused. Both you have to prove.
Both you have to prove. But in this case, Lordship, a victim's caste certificate has been exhibited at Exhibit 5 or over 4, Lordship.
Exhibit 4.
4, Lordship.
Victim, but accused is not there.
The
What,
IOS
you read the 93 OCR. It is regarding what? It is regarding again. It's a complaint case. Accused person do not belong to the
accused. Yes, Lordship.
accused. This is
Accused.
accused. Again accused.
Accused also.
Yes.
Lordship.
And what about the Supreme Court judgment? These two.
Supreme Court, Lordship, I am saying. That's right.
Ramesh Chand.
Lordship, first Supreme Court judgment, Lordship, Dasrath Sahu versus State of Chhattisgarh, 2024 ACC online, AC and 72. Lordship. Para 8, Lordship. Glance, Lordship.
A plain reading of
Plain
this
reading of
section
section
makes it clear
that
that
offense
the offense of outrage
outrage
of modesty
basically
should be committed with the intention that the victim belongs to the scheduled caste.
category, Lordship. It's a clear meaning of this section, Lordship. We will go to the next judgment, Lordship. I'm referring Supreme Court 2023-17
No,
ACC.
read then. We've gone through the FIR and shown testimony of the prosecutor and the complainant as extracted in the judgment of the High Court as well as the trial court. The case is projected in the FIR as shown testimony of the prosecutor would reveal that the prosecutor is complainant was engaged supporting household job in the house of the complainant who tried to authorize the modesty while the prosecutor was doing the household courts. Apparently, there's even from the highest allegation of the prosecutors, the offending act was not committed by the accused with an intention that you are doing so when the person belongs to the sexual class. He is that element has to come that he is doing this act
Just because of she belongs to
just because of she belongs. Merely doing the act is not offense. Merely,
21 with same conviction is
yeah.
say 31 XI. Para 10 of their judgment is irrelevant. Here the act is
Another matter you're talking.
again. Say item
Well,
21
let me see.
again.
Let me see.
Same with-
See the judgment says 3-1 XI outraging of modesty of women. 354 is not there.
Yes.
Only 354 parametria is applicable to there. But it says that the intention is only to hurt the HEST. That intention has to come on the evidence.
that has not come.
That judgment, read it. Have you given the judgment?
No, Lordship, I have not.
Why have you not given?
Sorry, Lordship, I don't have.
Read para 9.
Just giving Lordship.
Para 9 of Dasrathi Sahu.
May read or-
Read loudly so
Loudly.
you hear it.
Yes, Lordship.
And the other people will also understand.
We have gone through the FIR and shown testimony of the prosecution complainant as extracted in the judgments of High Court as well as that of the trial court. The case is projected in the FIR and the sworn testimony of the prosecution would reveal that the prosecution was engaged for doing household jobs in the house of accused appellant who tried to outrage her modesty while the prosecution complainant was doing the household chores. Apparently, thus, even from the highest allegation of the prosecution, the offending act was not committed by the accused with the intention that
With the intention.
intention that he was doing so upon as a person belong to scheduled caste.
Therefore, the 3-1X I will not be applicable. Let us see the evidence now. Evidence. What was the evidence? Who is the victim here?
PW1, Lordship.
Let us see what.
I know the accused standing in the dock. The occurrence took place about 1 year back on the Saturday at 8 a.m. My husband was working as a laborer with the accused, and for that, the accused was to pay his remuneration. As my husband was ailing, he sent me to the house of the accused to bring rice. I told the accused that
What is the intention is? Why she has done is she has questioned the measurement.
measurement by use of means of a
When
khata.
you are not giving the rice by properly measuring, when he said that
Yes.
out of the anger, he outraged the modesty. The intention is not because he is SC, therefore outraging modesty. Intention is he has objected to the measurement. That is the intention. If that part is the intention goes, 3x1 is not applicable. If this judgment is to be. This is the intention. Did you follow what? What do you say? Directly covered by the judge. Directly. You will see the intention. Okay? Intention. Unless the victim says that he attacked me or he outraged the modesty because I belong to SCST.
No, that-
Then the intention of outraging modesty is only to see that denigrate the women merely because he belongs to some others. So it may be a case of 354, but it can't be a case of para 3 of Yes, read it.
The accused abuse may have
That's all these things are all right. Abusing and all these things are all right. But what was the intention to outrage the modesty? Because she objected.
Yes,
That
Your Lordship, that's true.
waiting the
That
measurement.
wording was just, Lordship, that wording was an improvement stage in the evidence stage. Lordship.
That's right, but even then it doesn't come. The accused, that may attract some other offense, but not 3(1)(x). That's the judgment.
How to answer?
All these things, see, you have to see the intention before intention of the accused to have this conduct. Intention was something else, not because she was. She happens to be a CST. That's a different story. Happens to be a CST, no problem. But you have to draw the intention. If just imagine if she would not have been a CST woman, if this kind of provocation would have been there, he would have done it. Same act. He happens to be a CST. What to do?
He has taken the,
The intention.
Try to understand it that way. Analyze the thing. Suppose ordinary, he is not an HCST. She have done the same thing. To measurement ठीक करनो, she तापर रागी गिरिया करता था. But therefore the intention is because she has provoked,
not because
saying
of-
that you are not measuring properly.
not-
That was the reason she took away her and torn the blouse and whatever misbehavior she had done.
But thereafter he has abused saying such and such.
That's not the charge, sir. Abusing.
That is not the charge.
But
That is the improvement in the
Act,
later stage.
what is the act complaint of? Act complaint of is outraging modesty.
Of modesty.
This has happened. Thereafter abusing. He has been charged for the act which is not for the abuse.
So see, if you- Let's see if you
354 simpliciter could have been is made out. But 354 charge is not there.
let's say same wording is also used in Lordship judgment 2024 SCC online SC 74 Lordship para 10 Lordship can please use.
Which one? 2024?
24 SCC online SC 72
Yes.
para 10 Lordship. In the said judgment, the court dealt with a case involving offense under section 32V of SCST Act. The language of section 31XI of SCST Act is a parimetria, as the same also provides that the offense must be committed upon a person belonging to scheduled caste or scheduled tribes with the intention that it was being done on a ground of caste.
It was done in the ground of a caste.
Caste.
If it is done in the ground of the caste, then only 353.
That was the Lordship.
তারপরে কি কলা পরে গালি দিচ্ছি কলা পরে গালি দিচ্ছি।
para two.
And what is this judgment, Ramesh Chandra? Wait.
The accused, my lord, the accused dragged and catching hold of my hair and gave me fist blow. And, slap and kicks.
মেডিকেল তোমার নিজে তো মনা করি মেডিকেল এক্সাম নিজে পিটল
Yes. Thank you. And you come at 2. We'll finish it.
Same charge.
What was the charge? 354.
No, 3XI.
3XI.
XI.
What was
Another thing, my lord, no documentary evidence produced by the.
That's a different story. You tell me the allegation.
Allegation hଉଛି, she went to a village pond for cleaning the utensil. There the petitioner hold her hand. This is only allegation. And the investigation was conducted by ASI, which is not permissible under Rule 7.
Which item you are talking about?
21.
20?
21.
Which year?
Of 1995.
95.
Yes,
95, then act had come already.
already.
A rule has come.
Rule has come.
FIR? Date of FIR?
Date of FIR is 4/6/1994. 4/6/92.
92, na?
92.
92 then na? 92. 95 is the rule.
95 on
91.
31/3 1995.
That will not help.
Other.
That's ground gone.
Yes.
And this ground only,
This ground and the documentary evidence regarding the caste of the victim was not produced by the prosecution.
oral evidence is there.
Oral khali one said we belongs to the caste of Ghasi.
No document is.
No document is there.
Ghasi belongs to scheduled caste.
Scheduled caste. Ghasi belongs to scheduled caste.
No certificate is.
No certificate is there.
चलो at 2 o'clock करो.
Thank
इसको अभी पढ़ो. ठीक है. Yes. Right, Tim?
21.
Yes. Yes.
Sentence is my lord 2 years.
2 years.
2 years. Under section 31 XI of the SC Act and the fine is 2,000 rupees. Page 12 of the paper.
Who is victim?
Victim is PW2. She herself is the informant.
PW2.
Two. I know the accused standing in the dock by
By 2 people. Yeah. Two sentence is 2000, 2 years. Huh?
again.
Excellent. Let us see PW2.
I know the accused standing in the dock by face only.
1 minute.
About 1 year and 7 months back at about 3 p.m. while I was washing our utensils at a pond of my village, the accused caught hold of my hand and tried to drag me inside the water. Somehow I could manage to rescue from him. Then the accused gave 2 slaps, one on each of my cheek, and tore my frock from front side. Then I ran towards home crying. On the way, Costa Sandha met me.
Costa
Sandha,
PW3.
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 Met me and I informed him the incident. Then I narrated the incident to PW1 and my father. On the same date, I got the affair scribed through the Beda Sandha, PW4, the brother of Costa, and lodged it before the OIC Contaman at about 4:30 p.m. Putting on my way home from the pond, I found Costa. By that time, I had already covered 200 yards. It is not a fact that Costa is my own paternal uncle's son. I cannot say if the accused had any other brother. I disclosed before Costa, saying that the son of
But she doesn't say that I belong to HCSC anything.
No, yes, ma'am.
Huh?
My lord?
She doesn't say that I belong to.
No, she does not say that.
Doesn't say.
I was examined by the IO in this case. It is not a fact that I did not mention in the affair not stated before the IO that the accused inflicted 2 slaps to me on my cheeks. It is not a fact that I have not specifically stated to the IO.
Yes, come to para 3, PW3. Costa.
Costa. I know accused Pradeep Kumar Sahu standing in the dock. He is Sundhi by caste. I also know PW1 and 2 who are Ghasi by caste. On charge 4692, while I was plucking blackberry from a tree, I heard hulla. PW2 was raising hulla, so immediately I descended from that tree and carrying my small daughter who was there under the tree rushed to the spot where from the sound of crying was coming. On the way, I saw PW2 running. She disclosed before me that the accused Pradeep caught hold of her, but somehow she managed to escape. She had from the PW2. So it was confronted to PW2 and that was also made to the PW6 with the IO. She not stated before the IO regarding the assault and so far as the tore of her frock. The only remains that the accused caught her hand and dragged to the water. That part is there in the deposition of the PW6.
Hmm.
And so far regarding the caste particulars, that no documents has been exhibited from the list minority and as you can see only from the judgment, only seizure list, no exhibits are there.
Which PW4?
PW4 is the scribe of the affair.
The father,
He is
the
the
scribe.
no, not the father.
How related to the?
I scribe the affair in connection with this is that affair marked exhibit 4 and exhibit 4/1 is my signal. I read over and explained the contents of the same to PW2, who after finding the same to be correct. I scribed exhibit 4 in the house of PW1. PW2 detected the affair sentence by sentence to me. PW3 is my brother, has read up to third sentence. I was not examined by the IO in this case.
5 PW5?
5 is the
Father.
yes, ma'am. On 4/6/92, PW2, my daughter went to our village pond to wash the utensils. About half an hour thereafter, she returned home crying and disclosed that while she was washing the utensils in the bathing ghat, the son of Lingaraj Sunna all on a sudden came from her behind and caught hold of her hand, dragged her.
Lingaraj Sunna.
He stated that the son of Lingaraj Sunna.
Son
She
of-
coach, but in fact, she the accused is the son of Ruplal Sunna as per PW2.
I know. What is the Ruplal Sunna?
Ruplal Sunna.
Ruplal Sunna. Yes. Lingaraj Sunna coach.
Okay.
And he is Ruplal.
Okay. That was stated that it was disclosed by the and the paragraph 2 is the important. She stated that till today I have not known to the name of the accused standing in the dock, but I know that he is the son of Ruplal Sahu. Particularly the son.
Till I had not known to the name of the
accused
accused
standing
standing
in
in
the
the dock, but I know that he is the son of Ruplal.
Ruplal Sahu.
Here, यहाँ कुछ सुना
Sunna.
लिंगराज सुना कुछ
सुना,
रूपलाल कुछ ठीक. He also doesn't say about caste.
About caste.
Father also doesn't say.
Okay.
Not said about caste.
Again.
Father doesn't say, the victim doesn't say.
The victim
It
doesn't.
is the cousin brother, or who is PW3 the cousin brother.
PW3 one of the cousin brother.
Cousin brother. He says that he belongs to this caste. They
Belongs to the caste. And
But-
apart from PW1 भी कहुଛି PW1 is the mother. PW1. ସେ କହୁଛି ଯେ but we belongs to Ghasiya caste. But no particulars of caste certificate has been obtained by the IO, and that also not produced before the trial court. He later direct decision of the court. And occurrence of 92 in the meantime 31 years.
No certificate is.
No certificate. IO is PW6. That paragraph 5 that was
Ready.
not
PW6.
PW6.
I have already.
I was the ASI of
Yes, sir. What do you say?
Here the conviction is the 31XI of the SGT schedule. 31XI is clearly says, your lordship. Assaults or uses force to any woman belonging to scheduled caste or scheduled tribes when with intent to dishonorable outrage or modesty, your lordship. So for PW2 is the victim, and it is clearly stated that while he was washing the utensils in the pond, the appellant accused prisoner thrown to the her.
What is your answer to the judgments?
There is an ocular evidence clear that PW2, mother of the victim, has clearly stated we are the belongs to the caste of.
Yeah.
Though there is no medical caste certificate is exhibited by the prosecution
then-
trial court. But there is the clear evidence of the PW2, 3 and 5.
What is clear evidence?
We are belong to the
Then-
caste of the Ghasi that
क्या गणेश हो गया?
that to be confronted by the cross whether that belongs to the Ghasi or
And
not.
your own claim will not help unless the IO says that yes, I verified that she belongs to this, or I got the certificate, anything of that sort.
It is the there is an evidence that the PW2 and one
The
5.
problem is, see, what is scheduled caste, what is scheduled tribe? What is that? Under the constitution, it is described. Under the schedule. The IO should say that he said Ghasi, and I checked it in the entry number so and so, Ghasi is included. Then the oral evidence is satisfied.
And
Merely a illiterate person says that I am Ghasi, so I am SC, ST. What do they know? Schedule, constitutional schedule. Do they know? No. So how will you establish this kind of? These are very stringent law.
but super caste certificate is not concerned.
What is there then? And what is intention? Intention to outrage modesty is relatable to his caste. It's not. That is not the idea. Merely because she belongs to a particular caste, therefore this girl is being humiliated. Unless that element comes, then
But statute says, Your Lordship, there is intention is not clear. 3x, x or xi.
have you read that judgment?
But-
Judgment.
But statute, Your Lordship, before vacation,
Judgment. This statute is now interpreted by the Supreme Court.
yes, Your Lordship, before launch, Your
Ah,
Lordship, that part.
Then how will you get over that?
But
And the trial court obviously not has done now. Trial court is not obviously
The
not.
Appeals Court also said that relying this upon the provision.
Give
of-
way.
Yes. These judgments I have given, one of our Honorable High Court, that is 61 OCR, ସେଥିରେ the caste particulars must be produced for
if you clear it is
no
not there.
documentary evidence is produced, accordingly acquitted. And so by the 2008 OLR is
Which
concerned,
paragraph is 61?
61 paragraph 5.
5. What is it?
Admittedly, in this case, no such documentary evidence has been tendered proving the caste of the informant and her brother that they are the members of scheduled caste. It is stated in the FIR that the informant was abused by accused Khogeshwar, and he had hurled the abusive words, those are so and so. The trial court, as it appears, has taken into consideration that as the accused person no here claim of the exemption of being member of SC and ST, which provides them immunity of prosecution under the Act. On the face of the evidence of PW1 receiving corroboration from the FIR, she is to be held to be a member of scheduled caste, as prosecution version is that she was insulted by calling her caste. The view of the trial court that simply because of the evidence on record that accused Khogeshwar stating as so and so, the same is enough to hold PW as member of scheduled caste, in my concept, not sustainable in the eye of law. ସେଥିରେ document
ଧୋବିଣୀ କହିଥିଲା.
ଆଜ୍ଞା
That witnesses say ଧୋବିଣୀ.
ଆଜ୍ଞା ଆଉ ତାପରେ ଯୋଉ 2008 supplementary OLR ଟା ଦେଇଛି ସେଥିରେ ଯୋଉ conviction was sustained in respect of other offences and paragraph 8 ମାନେ
Which one?
paragraph 8 2008 supplementary 1 OLR para 8.
Yes.
Coming to the question as to whether appellants could be convicted for commission of offense under section 3 of the SCST PO Act or not, it appears from the evidence of the prosecution witness that nothing has been said by any witness to the effect that the victim girl was Katia by caste and the appellants committed the offense on the ground that she is a scheduled caste. Similarly, there is also no evidence to show that the appellant Munna Patra committed rape on the ground that she is a scheduled caste person. In this connection, reference was made of the Honorable Apex Court in the case of Mosumas Hassan Shah Musalman versus State of Maharashtra. Accordingly, the 3-1 XI sentence was set aside, others were confirmed. Paragraph 9, in view of the discussions made
There
above,
after this one, Dasrathi.
paragraph 9.
What is
Last with Dasrath.
Hmm.
Dasrath,
Which
paragraph 10 re.
same judgment with the case involving the offense and-
Para 8, 9, as was read before the before lunch. In para 10, in the said judgment, this court dealt with a case involving offense under section 3(2)(b) of the SCST Act. The language of section 3(1)(xi) of the SCST Act is perimeter as the same also provides that the offense must be committed upon a person belonging to scheduled caste, scheduled tribe with the intention that it was being done on that
On the
ground of
ground of the,
caste. Caste.
unless you say that the ground of the caste, it is done.
To that, we'll also kindly
See,
glance.
why,
the
I'll tell you
page.
what kind of, see somebody, if the person belongs to SC/ST community, member, they go to fetch water from the well. And the villager says, no, no, you are SC/ST, we will not allow. Then, but for their caste, they were prevented. So then it comes on the ground of their caste, they are being humiliated. Then the offense.
It is simpliciter maybe 354. Dragged her hand only.
Maybe
No,
354 charge is there.
No, charge not there.
That's-
Your Lordship, PW1, the mother of the victim.
I read it.
is Proceeding part, Your Lordship, case 22, Your Lordship. This clearly said, but we being cast, Ghasi by caste, we are not allowed to use the water from these water sources, Your Lordship.
But that was not the charge here.
Charge.
Charge is 354 charge.
Water charge and
Water
water
charge.
alga charge ଅଛି.
Water.
If not allowed to use
That is a specific offense.
Specific offense is
Specific
there.
offense. That is not charge. X, I think. That is X.
Right.
X or something. There is a specific offense for that. Right.
Yes, sir. 3x triple line.
That is a specific. Right. Petitioner is agreed by the judgment and judgment of conviction. Judgment of conviction and order of sentence. They get first 1/3/1995. 95, no? 95 passed by issued in session judge full one in ST case number 4 of 1995. Whereby the petitioner on the petitioner on being convicted for offense under section 3(1)(xi) of SC and ST POA Act has been sentenced to undergo religious imprisonment for 2 years and to pay fine of rupees 2,000 and default to further have to arrive for 4 months. For 4 months. The prosecution's case is sold. And after investigation, charge sheet was filed. And on the status of the appellant, on the denial stand of appellant in claim of trial, was put to trial. The prosecution examined as many as 6 witnesses. How many witnesses examined? 6 witnesses. 6 witnesses. Not detailed witnesses. Okay. And exhibited 4 documents. 4 documents. The trial court after analyzing the evidence. Derivative going finding. Para 6. Petitioner is agreed by such finding because as per the appellant, petition as per the appellant, the trial court has arrived arrived at the aforementioned finding by wrong petitions and evidence. Mr. Dwivedi, you have a comment. for the third learning to go, or has taken me to see evidence on record and point out to the inner contradiction. Apart from that, Mr. Dividi has submitted that the case, even if the prosecution case is prosecution version through the witnesses are accepted at its face value, no case and exception one XI of HC state is made out because because the accused there was no intention on the part of intention attributed by the victim on the part of the appellant to commit the crime to denigrate the with an intention to what is that language with an intention that it is being done on the ground of her caste, their hair caste. He has relied upon the judgment of Supreme Court in 2024, Live Law SC 66, 66, neutral citation review, 2024 INSC 68, Dasarath Sahu versus State of Chhattisgarh. Further, he submitted that in the present case, there is no, the prosecution has failed to bring on record any evidence regarding establishing the caste of the victim, caste of the victim. He submitted that neither oral, neither sufficient oral evidence has come on record, nor any iota of evidence in the name of documentary evidence has borne on record to suggest that the victim belongs to SC, ST. On that ground itself, the offense ground itself, the appellant is entitled to an acquittal as the offences are under forms. He has relied upon the judgment of this court reported in 2015 61 OCR 821. 821. He is also 21. In the light of the judgment relied upon by the appellant, I have analyzed the evidence on the court. PW2 is the victim in the present case who, in her testimony, has stated that the accused got hold of her hand and tried to drag her inside the water when she was washing her utensils in the pond. She somehow could manage to escape from the clutches of the accused. She further alleged that further deposed that the accused gave 2 slaps, one on each of his cheek, and tore her frock from the front side. She further stating that she ran out, ran away towards her home, crying. At that point in time, PW3 Kasta Sandha met her in the way and she narrated the incident to her. In the entire testimony of the said victim PW2, she has not stated that she belongs to either a scheduled caste or scheduled tribe, and she has not even stated her caste in her examination, in her testimony. PW3, PW4 is the father is PW5 is the father of the victim. He in his testimony, he is a hearsay witness. He has not witnessed the incident. He has deposed before the court, stating that he heard from her daughter that when she had been to the pond for washing the utensil and washing, son of one Lingaraj Suna came all on a sudden and got hold of her daughter, his daughter, and dragged her inside the water, uh, water, and tore her frock from the front side. She raised Pulla and the accused somehow released her. The said witness has also sustained sustained it is Mr. Divedi, learned counsel for the appellant, pointed out that in the accused is the father name of the accused is the son of one Rupak Ruplal Sahu. Ruplal Sahu. Therefore, the evidence of PW5, in the cross in the examination chief, also he has stated that the accused is the son of one Lingaraj Suna. Suna. However, in the cross examination, the said witness corrected himself and stated that he doesn't know the name of the accused, but he knows that he is the son of Ruplal Sahu. Ruplal Sahu. The apparent contradiction in the testimony of the said witness in his cross examination and in examination in cross examination creates a serious doubt. It is also pointed out that the said witness, who is the father of the victim, has also not stated anywhere that she either belongs to scheduled caste or scheduled tribe. Even he has not disclosed his caste, his caste. It is only the PW5, PW4, no, PW3, who is the cousin brother of the PW2 victim, had stated that belongs to which caste? Sundi. He is Sundi. For this one, Sundi. PW Hasi, huh? Hasi. Stated that the accused, the PW1 and PW1, 2, and 5 belongs to Hasi by caste. Hasi by caste. Although she has supported the version of PW2 regarding the narration of the incident, incident with little variation. But fact remains that he is a hearsay witness. Hearsay witness, and he has not seen the incident by PW1 is the mother of the victim PW2. She, in her statement, she also is not a eyewitness to the occurrence. She has only heard it from her daughter. She also narrated the incident and has been described to her by her daughter. The said witness has deposed that the victim is she belongs to Ghasi by caste. It is apparent on record that apart from the testimony of PW3 and 1-3, they have stated that the victim belongs to Ghasi by caste. No other evidence to substantiate that, to establish that the victim belongs to either scheduled caste or tribe has common record. And the caste certificate has also not been proved on record. In that, on the face of the said evidence, the judgment cited by Mr. Divedi in Khageshwar Kunal Supra, assume importance. Para 5 of the judgment reach as an para 5 to the first reach answer. The main contention raised by Mr. Dwivedi is that even if the evidence of all the witnesses are taken at its face value, no offense under section 3 XI is made out. The Madam, he has relied upon the judgment of the Supreme Court in the matter of Dasarathi Sau Supra. The Honorable Supreme Court in the state judgment at para 7, 8 and 10 has held his hand. The fact of the present case is quite akin to the fact of the case in the case of Dasarathi Sahu. It is a fact that the evidence has come on record that the accused has outraged has cut hold of the hands of the victim and dragged her into the water and torn her frock from the front side and slapped her. But which attract the offense, which satisfies the ingredient of an offense under section 354 IPC and also satisfy the part of the ingredient of the offense under section 31X. But from the evidence of PW2, the intention part is not coming to the fore to hold the appellant guilty for offense under section 31X. Particularly for two reasons: that neither the victim herself nor from the evidence of other witnesses it is germinating from the record that the act complained of committed by the appellant is with an intention that it was being done on the ground of the cast of PW2. That being so, I'm of the considered view that the prosecution has failed to establish the case of case against the appellant for offense under 3 so, and hence the appellant is entitled to benefit of doubt. While extending the benefit of doubt, the input judgment is set aside and the accused is acquitted. Yeah. Yes.
Small matter,
You have made it small, it is really small.
Yeah.
You have made it small or it is really small? I think you have made it. It's a bigger file.
Merit in the sense, my lord. Now the
323,
accused is
6 months.
323.
323, 6 months. So be the victim.
Accused is on 73 years old.
So be the victim and doctor's evidence. Finish. So be the victim. What? Who is victim?
It all. What is that? Allegation is 3 years second. Without any discharge, it is a converted 323 or conviction is for 6 months. Accused is in custody 26/6/2019-96.
Arrested on 26.
On 26/6/1996.
96.
And released on bail 8/7/1996.
96.
15 days.
15 days.
Okay. Admittedly, the injury is simple nature.
Therefore 323. Therefore, 323.
Yes, yes, simple in nature, but I draw your attention. Before going through the merits of the case, my lord, I draw your attention on the P8, who is the IO.
PW8, huh?
IO.
Yes. Yes. Yes.
If your lordship, very fairly concealed, if at this stage, if your lordship keep it for period and organ, I have no objection. Because of taking the age intervention, at the age at the occurrence, he was on 45. Now he is on 73. But that is the reason. I fairly submit, my lord.
No, you are not aiming at an acquittal. You are not aiming at an acquittal.
No.
Then why should I labor on that?
If your lord say nothing to say.
Huh? Undergone. With little fine, of course. What is the fine amount?
Fine.
IPC. And fine or fine? IPC.
No fine amount, sir.
Yeah, fine is not there,
No,
but
it is thought to the accused,
it
therefore
and
hold
fine?
the under section 323, whereas there is no fine amount.
Or fine. Or fine. It's all right. Fine is not required. Fine is not required. Extendable to 323. What is the age you say? Age of the appellant is 70?
73, my lord. At the age of in ST, he is 45. That is, yeah. Now he is 72 plus.
Mrityunjay, huh? Mrityunjay Panda. Equal. Charge sheet, just see the charge sheet. 29, na? Mrityunjay. Charge sheet. TRC report.
Judgments are the case, there are 45 achi.
No. You see the file for
Under 55, that is the ST in 97. Now
1956.
72 plus 73. And the report is also जो मगाई थे due to old age he is
ठीक है जी.
and another is that weapons are not produced before the court or not to exhibit. So Thenga जो हुई थी that has not. And for that
Who is the what do you call the victim?
victim is PW 5 minute, PW 6 minute.
6. Yeah? Sustain injury. Who is? There are 3 accused persons, huh? But convicted, one of them is convicted. The rest acquitted. What happened? All of them are acquitted.
That statement is a contradiction. For that reason,
No.
I draw your attention to the PW 7.
Three accused persons, 3 people face the trial, isn't it? 3 of you have faced the trial. And what happened to the other 2?
Other accused were acquitted in the trial.
Where does it say? 13, huh? this appeal, and this appeal is directed against the judgment dated so the hearts also the prosecution cases so okay. Three accused persons. Witnesses, but witnesses about the three accused persons, including the present appellant, they stood charged for offence under section 307 IPC. 307 IPC. After the in the present case, the PW6 is the victim.
Yes.
PW6 is the injured. PW6 is the injured victim who has reposed that on 24/6/1996 about 4:30 to 5 p.m. Accused persons came. Accused persons came. Murtunjay Panda, the appellant, ये para two of the dealt blow by body, dealt blow by body on the head. So that part of the statement of the victim should corroborate. Who is the doctor? Doctor. Who is the doctor?
Doctor was PW7.
PW?
7.
Should corroborate it with the testimony of PW7, the doctor who found the following injuries. Following injuries, no? Injuries, PW7 following injuries. On the basis of the trial court found the injury to be trial court relied upon the testimony of PW7 and finding the injuries to be simple and there is no intention to cause to kill intention on the part of the appellant to kill the victim PW6 arrive at the following finding. Finding para para 12. Para 12. The appellant is the sole appellant who has been convicted. Anyway, the trial court, on the basis of the aforementioned finding, the trial court acquitted the co-accused Sarat Hon'Ble and Dhananjay Panda and found the appellant guilty for offence under section 323 IPC and accordingly on that count sentence the appellant to undergo RI 6 months. 6 months. The appellant is agreed by the state for judgment of conviction on the order of sentence. Hence, has filed the appeal. Mr. So at the outset submitted that the petitioner is at present at the time of incident, the petitioner was 45 years and his date of year is 1956 and age born of record. Hence at the present petitioner is appellant is 73 years old. At the time of during trial he was arrested.
No.
After judgment.
After
No, after judgment.
I don't know, 26.
26 arrested, huh?
26, 96.
When was the judgment? 99. Judgment is 99. Then, during the trial, the petitioner, the appellant was arrested on 26/6/1996 and was admitted to bail on 8/7/1996. Therefore, he has undergone incarceration for a period of 15 days as a UTP. The MP note was passed on 15/1/1999.
2099.
Yes, the
99.
benefit of provisions under section 389 CR. He at the outset submits that in view of the aforementioned, he doesn't want to press the present appeal insofar as the conviction is concerned, and confine his argument to the proposed quantum of sentence and so the authority to alter it. Tick. I think yes.
Item 10, number, small man.
Item 10. Yes. Ready.
Yes, madam.
Item 10. Good 94. Yes.
Item 10, PO Act, Section 6. Under 21 years of age, my lord. Section 324, 302, 34 acquitted. 324, Section 6, I was and Section 6 was applicable to me. 10,000 rupees khali deichanti and 1 year.
To keep peace and tranquility for a period of 1 year and receive the
So
sentence.
you are agreed by that.
That's
You want an acquittal. What do you want?
I'm just agreed by that 10,000 rupees.
No, that's right, but
1 year.
what do you want? The PO, the benefit of PO has already been granted to you.
Yes.
Yes, madam.
So what do you want?
I have appeal for that amount, the 10,000 rupees and one acquittal, my lord, in that ground only.
Acquittal, you have to make out a case for acquittal. It is not acquittal is not
No,
by
no.
way of right.
No, my lord, that 10,000 rupees and 1 year of correction period, only that's on a challenge. I had only
The-
challenged that.
10,000 you might have already deposited.
Might have no instruction for
The
that.
bond of rupees 10,000, not the cash bond.
Bond,
For
bond.
1 year. You need to ascertain the conduct
Conduct
of
of
the accused appellant.
That is always
That
there.
period.
Where is that? Which part of
That is the impugned page 17 of the last part of the judgment, your lordship. Internal page 17, your lordship.
Yes. Ready. The legal counsel for the state raises no dispute on the position of law, but evidentiary, but vehemently argued that since the convict was originally charged under section 302 IPC, he should be visited with the rigorous imprisonment, and I am not able to accept his contention. 323, 324, 324.
Okay.
Merely on the provisions of sections for so and so. Then what does he say? From the rationale of the above provision,
Para 23.
as well as ଅଛି ଧର ହାଡ଼ କପି ଅଛି କିନ୍ତୁ ଶୁଣ କିଛି ଠିକ ଅଛି
Para 23.
ଠିକ ଅଛି then it will be better, huh? The above background case direct the accused to execute a bond of 10,000 to give. A bond you will give bond. What is the big deal?
My lord.
It's not a fine.
No.
Only bond.
Well,
A purely bond.
1
And
year,
at this period,
Already-
you see, you might have already given it.
my lord.
So then what remains? You have served out the sentence.
My lord.
Nothing. Bond you might have given already.
My lord, to be only very fair and part, this priority matters more than 20 years. Recently, after police investigated my house and my premises, they served me upon this copy. Recently, I just entered the Vaklatnama. And they say that the person who was taking care of these cases, the advocate learned counsels, nobody is, present anymore. And as he said that he was a child and he is not qualified enough to answer these kind of questions. And he just said that he has never went to prison. He just surrendered and was released on bail during that time.
Because of the probation, he will never go to prison,
My-
obviously.
My lord,
So
that's
he might have given the bond in that period.
bond instruction. I cannot say he will.
Bond, obviously, this
My-
that bond means you have to just, you need not give money, you
that's-
sign 10,000.
1994, the Honorable Court for prayer for stay is rejected. Means this order might have the appellant have deposited the said amount before the trial court for a period
Where
of
is
time.
that?
There was a miscase. There was a
Where is
miscase.
that?
That is your lordship, running page, digital page 2, your lordship.
Huh?
Digital page 2.
Stay is rejected.
Yes, yes. Her prayer for stay is rejected.
Bond ଦେଇକି ଖତମ ହେଇଯାଇଥିବ।
Yes.
ମୁଁ କିଛି କହିବି ପାରୁନି କାରଣ ମତେ କିଛି ହେଲ୍ପ କଲେ ବି-
କହିବା କଣ ଦରକାର, ଦୁସୁଚି ସେଗୁଡାକ ଖତମ କରିଦବା।
ଆଜ୍ଞା
ଖତମ କରିଦବା।
ଆଜ୍ଞା।
କରିଦବା। ଦେଖ ये पूरा न्यूज़ ये पूरा न्यूज़ बैक टू प्रोसीडिंग चालू लिख दो, लास्ट प्रोडक्ट लिख दो और कर दो। The petitioner was a petitioner has been convicted for offense under section 324 IPC 324 IPC when he was heard on the question of sentence. The trial court, while dealing with the case of the petitioner on the question of sentence, the trial court taking into consideration section 6 of provision of offenders act and section 360 of CRPC and arrived at the conclusion that the petitioner is the appellant is entitled to the treatment under section 6 of provision of offenders act. Accordingly, directed the petitioner appellant to execute a bond of 10,000 to keep peace and tranquility, peace and tranquility. Para 23, for a period of 1 year and to receive the sentence when called upon during the reposal period. During the appellant has challenged the conviction or judgment of conviction or order of sentence. When the sentence in this appeal, when this appeal was heard, this court might order dated 13/1/1994 was the following order in which Kumar Gandhi heard the prayer for stay is rejected, the missed case is dismissed. तार ऊपर लिख दो एडमिट, एडमिट ऊपर लिख दो एडमिट heard prayer for dismiss. From the aforementioned order of this court, it is apparent that the appellant has already furnished the required bond as directed by the trial court, and the period of the probation period of 1 year has already lapsed. In that view of the matter, the Sir counts for the appellant submits that nothing survives to be appealed. Accordingly, the appeal will be disposed of. Appeal is disposed.
So blessed.
Tuesday करो because I have to give some judgment now. Okay. So we should get to